Disclaimer: we cannot warrant that this code is up to date or free from typographical errors. As much as possible, we would advise you to continue to refer to an updated hard copy of the code while listening to this. Good luck with your studying. Presidential Decree Number 612. December 18, 1974. Ordaining and instituting an insurance code of the Philippines. I, Ferdinand E. Marcos, President of the Philippines, by virtue of the powers in me vested by the Constitution, do hereby decree and order the following general provisions. Section 1. This decree shall be known as the Insurance Code. Section 2. Whenever used in this code, the following terms shall have the respective meanings hereinafter set forth or indicated, unless the context otherwise requires. 1. A contract of insurance is an agreement whereby one undertakes for a consideration to indemnify another against loss, damage or liability arising from an unknown or contingent event. A contract of suretyship shall be deemed to be an insurance contract, within the meaning of this code, only if made by a surety who or which, as such, is doing an insurance business as hereinafter provided. 2. The term, doing an insurance business, or transacting an insurance business, within the meaning of this code, shall include a making or proposing to make, as insurer, any insurance contract, the making or proposing to make, as surety, any contract of suretyship as a vocation and not as merely incidental to any other legitimate business or activity of the surety. C. Doing any kind of business, including a reinsurance business, specifically recognized as constituting the doing of an insurance business within the meaning of this code. D. Doing or proposing to do any business, in substance equivalent to any of the foregoing in a manner designed to evade the provisions of this code. In the application of the provisions of this code, the fact that no profit is derived from the making of insurance contracts, agreements or transactions, or that no separate or direct consideration is received therefore, shall not be deemed conclusive to show that the making thereof does not constitute the doing or transacting of an insurance business. 3. As used in this code, the term commissioner means the insurance commissioner. Shamraville's Virtual Law Library Chapter 1. The Contract of Insurance. Title 1. What may be insured. Section 3. Any contingent or unknown event, whether past or future, which may indemnify a person having an insurable interest, or create a liability against him, may be insured against, subject to the provisions of this chapter. The consent of a husband is not necessary for the validity of an insurance policy taken out by a married woman on her life, or that of her children. Any minor of the age of 18 years or more may, notwithstanding such minority, contract for life, health and accident insurance with any insurance company duly authorized to do business in the Philippines, provided the insurance is taken on his own life and the beneficiary appointed is the minor's estate or the minor's father, mother, husband, wife, child, brother or sister. The married woman or the minor herein allowed to take out an insurance policy may exercise all the rights and privileges of an owner under a policy. All rights, title and interest in the policy of insurance taken out by an original owner on the life or health of a minor shall automatically vest in the minor upon the death of the original owner unless otherwise provided for in the policy. Section 4. The preceding section does not authorize an insurance for or against the drawing of any lottery or for or against any chance or ticket in a lottery drawing a prize. Section 5. All kinds of insurance are subject to the provisions of this chapter so far as the provisions can apply. Title 2. Parties to the contract. Section 6. Every person, partnership, association, or corporation duly authorized to transact insurance business as elsewhere, provided in this code, may be an insurer. Section 7. Anyone except a public enemy may be insured. Section 8. Unless the policy otherwise provides, where a mortgagor of property effects insurance in his own name providing that the loss shall be payable to the mortgagee or assigns a policy of insurance to a mortgagee, the insurance is deemed to be upon the interest of the mortgagor, who does not cease to be a party to the original contract, and any act of his prior to the loss, which would otherwise avoid the insurance, will have the same effect, although the property is in the hands of the mortgagee, but any act which, under the contract of insurance, is to be performed by the mortgagor may be performed by the mortgagee therein named, with the same effect as if it had been performed by the mortgagor. Section 9. If an insurer assents to the transfer of an insurance from a mortgagor to a mortgagee and, at the time of his assent, imposes further obligation on the assignee making a new contract with him, the act of the mortgagor cannot affect the rights of said assignee. Title 3. Insurable interest. Section 10. Every person has an insurable interest in the life and health of himself, of his spouse and of his children, via any person on whom he depends wholly or in part for education or support, or in whom he has a pecuniary interest, see of any person under a legal obligation to him for the payment of money or respecting property or services, of which death or illness might delay or prevent the performance, and be of any person upon whose life any estate or interest vested in him depends. Section 11. The insured shall have the right to change the beneficiary he designated in the policy, unless he has expressly waived this right in said policy. Section 12. The interest of a beneficiary in a life insurance policy shall be forfeited when the beneficiary is the principal, accomplice, or accessory in willfully bringing about the death of the insured, in which event the nearest relative of the insured shall receive the proceeds of said insurance, if not otherwise disqualified. Section 13. Every interest in property, whether real or personal, or any relation to or liability in respect thereof, of such nature that a contemplated peril might directly damnify the insured, is an insurable interest. Section 14. An insurable interest in property may consist in an existing interest, b. an insured interest, founded on an existing interest, or c. an expectancy, coupled with an existing interest, in that out of which the expectancy arises. Section 15. A carrier or depository of any kind has an insurable interest in a thing held by him as such, to the extent of his liability but not to exceed the value thereof. Section 16. A mere contingent or expectant interest in anything not founded on an actual right to the thing, nor upon any valid contract for it, is not insurable. Section 17. The measure of an insurable interest in property is the extent to which the insured might be damnified by loss or injury thereof. Section 18. No contract or policy of insurance on property shall be enforceable except for the benefit of some person having an insurable interest in the property insured. Section 19. An interest in property insured must exist when the insurance takes effect and when the loss occurs, but not exist in the meantime. An interest in the life or health of a person insured must exist when the insurance takes effect, but need not exist thereafter or when the loss occurs. Section 20. Except in the cases specified in the next four sections, and in the cases of life, accident, and health insurance, a change of interest in any part of a thing insured unaccompanied by a corresponding change in interest in the insurance suspends the insurance to an equivalent extent until the interest in the thing and the interest in the insurance are vested in the same person. Section 21. A change in interest in a thing insured after the occurrence of an injury which results in a loss does not affect the right of the insured to indemnity for the loss. Section 22. A change of interest in one or more several distinct things separately insured by one policy does not avoid the insurance as to the others. Section 23. A change on interest, by will or succession, on the death of the insured, does not avoid an insurance, and his interest in the insurance passes to the person taking his interest in the thing insured. Section 24. A transfer of interest, by one of several partners, joint owners, or owners in common, who are jointly insured, to the others, does not avoid an insurance, even though it has been agreed that the insurance shall cease upon an alienation of the thing insured. Section 25. Every stipulation in a policy of insurance for the payment of loss, whether the person insured has or has not any interest in the property insured, or that the policy shall be received as proof of such interest, and every policy executed by way of gaming or wagering, is void. Title 4. concealment. Section 26. A neglect to communicate that which a party knows and ought to communicate is called a concealment. Section 27. A concealment, whether intentional or unintentional, entitles the injured party to rescind a contract of insurance, as amended by Writing Jing Cast of the LG. 874 Section 28. Each party to a contract of insurance must communicate to the other in good faith all facts within his knowledge which are material to the contract and as to which he makes no warranty and which the other has not the means of ascertaining. Section 29. An intentional and fraudulent omission on the part of one insured to communicate information of matters proving or tending to prove the falsity of a warranty entitles the insurer to rescind. Section 30. Neither party to a contract of insurance is bound to communicate information of the matters following except in answer to the inquiries of the other, those which the other knows, be those which, in the exercise of ordinary care, the other ought to know, and of which the former has no reason to suppose him ignorant, see those of which the other waives communication, be those which prove or tend to prove the existence of a risk excluded by a warranty, and which are not otherwise material, and e those which relate to a risk accepted from the policy and which are not otherwise material. Section 31. Materiality is to be determined not by the event, but solely by the probable and reasonable influence of the facts upon the party to whom the communication is due, in forming his estimate of the disadvantages of the proposed contract, or in making his inquiries. Section 32. Each party to a contract of insurance is bound to know all the general causes which are open to his inquiry equally with that of the other, and which may affect the political or material perils contemplated, and all the general usages of trade. Section 33. The right to information of material facts may be waived either by the terms of the insurance or by neglect to make inquiry as to such facts, where they are distinctly implied in other facts of which information is communicated. Section 34. Information of the nature or amount of the interest of one insured need not be communicated unless in answer to an inquiry, except as prescribed by Section 51. Section 35. Neither party to a contract of insurance is bound to communicate, even upon inquiry, information of his own judgment upon the matters in question. Title 5. Representation. Section 36. A representation may be oral or written. Section 37. A representation may be made at the time of, or before, issuance of the policy. Section 38. The language of a representation is to be interpreted by the same rules as the language of contracts in general. Section 39. A representation as to the future is to be deemed a promise, unless it appears that it was merely a statement of belief or expectation. Section 40. A representation cannot qualify an express provision in a contract of insurance, but it may qualify an implied warranty. Section 41. A representation may be altered or withdrawn before the insurance is effected, but not afterwards. Section 42. A representation must be presumed to refer to the date on which the contract goes into effect. Section 43. When a person insured has no personal knowledge of a fact, he may nevertheless repeat information which he has upon the subject, and which he believes to be true, with the explanation that he does so on the information of others, or he may submit the information in its whole extent to the insurer, and in neither case is he responsible for its truth, unless it proceeds from an agent of the insured, whose duty it is to give the information. Section 44. A representation is to be deemed false when the facts fail to correspond with its assertions or stipulations. Section 45. If a representation is false in a material point, whether affirmative or promissory, the injured party is entitled to rescind the contract from the time when the representation becomes false. The right to rescind granted by this code to the insurer is waived by the acceptance of premium payments despite knowledge of the ground for rescission, as amended by Writing Jing Cast of the LG. 874. Section 46. The materiality of a representation is determined by the same rules as the materiality of a concealment. Section 47. The provisions of this chapter apply as well to a modification of a contract of insurance as to its original formation. Section 48. Whenever a right to rescind a contract of insurance is given to the insurer by any provision of this chapter, such right must be exercised previous to the commencement of an action on the contract. After a policy of life insurance made payable on the death of the insured shall have been enforced during the lifetime of the insured for a period of 2 years, from the date of its issue or of its last reinstatement, the insurer cannot prove that the policy is void ab initio or is rescindable by reason of the fraudulent concealment or misrepresentation of the insured or his agent. Title 6. The policy. Section 49. The written instrument in which a contract of insurance is set forth is called a policy of insurance. Section 50. The policy shall be in printed form, which may contain blank spaces, and any word, phrase, clause, mark, sign, symbol, signature, number, or word necessary to complete the contract of insurance shall be written on the blank spaces provided therein. Any writer, clause, warranty or endorsement purporting to be part of the contract of insurance and which is pasted or attached to said policy is not binding on the insured unless the descriptive title or name of the writer, clause, warranty or endorsement is also mentioned and written on the blank spaces provided in the policy. Unless applied for by the insured or owner, any writer, clause, warranty or endorsement issued after the original policy shall be countersigned by the insured or owner, which countersignature shall be taken as his agreement to the contents of such writer, clause, warranty or endorsement. Group insurance and group annuity policies, however, may be typewritten and need not be in printed form. Section 51. A policy of insurance must specify the parties between whom the contract is made, the amount to be insured except in the cases of open or running policies, see the premium, or if the insurance is of a character where the exact premium is only determinable upon the termination of the contract, a statement of the basis and rates upon which the final premium is to be determined, d. the property or life insured, e. the interest of the insured and property insured, if he is not the absolute owner thereof, f. the risks insured against, and g. the period during which the insurance is to continue. Section 52. Cover notes may be issued to bind insurance temporarily pending the issuance of a policy. Within 60 days after the issue of the cover note, a policy shall be issued in lieu thereof, including within its terms the identical insurance bound under the cover note and the premium. Therefore, Chamberlain's Virtual Law Library cover notes may be extended or renewed beyond such 60 days, with a written approval of the Commissioner if he determines that such extension is not contrary to and is not for the purpose of violating any provisions of this code. The Commissioner may promulgate rules and regulations governing such extensions for the purpose of preventing such violations and may by such rules and regulations dispense with a requirement of written approval by him in the case of extension in compliance with such rules and regulations. Section 53. The insurance proceeds shall be applied exclusively to the proper interest of the person in whose name or for whose benefit it is made unless otherwise specified in the policy. Section 54. When an insurance contract is executed with an agent or trustee as the insured, the fact that his principal or beneficiary is the real party in interest may be indicated by describing the insured as agent or trustee, or by other general words in the policy. Section 55. To render an insurance effected by one partner or part owner applicable to the interest of his co-partners or other part owners, it is necessary that the terms of the policy should be such as are applicable to the joint or common interest. Section 56. When the description of the insured in a policy is so general that it may comprehend any person or any class of persons, only he who can show that it was intended to include him can claim the benefit of the policy. Section 57. A policy may be so framed that it will inure to the benefit of whatsoever, during the continuance of the risk, may become the owner of the interest insured. Section 58. The mere transfer of a thing insured does not transfer the policy, but suspends it until the same person becomes the owner of both the policy and the thing insured. Section 59. A policy is either open, valued, or running. Section 60. An open policy is one in which the value of the thing insured is not agreed upon, but is left to be ascertained in case of loss. Section 61. A valued policy is one which expresses on its face an agreement that the thing insured shall be valued at a specific sum. Section 62. A running policy is one which contemplates successive insurances and which provides that the object of the policy may be from time to time defined, especially as to the subjects of insurance, by additional statements or endorsements. Section 63. A condition, stipulation, or agreement in any policy of insurance, limiting the time for commencing an action thereunder to a period of less than 1 year from the time when the cause of action accrues, is void. Section 64. No policy of insurance other than life shall be cancelled by the insurer except upon prior notice thereof to the insured, and no notice of cancellation shall be effective unless it is based on the occurrence, after the effective date of the policy, of one or more of the following: a non-payment of premium, the conviction of a crime arising out of acts increasing the hazard insured against, c. discovery of fraud or material misrepresentation, d. discovery of willful or reckless acts or omissions increasing the hazard insured against, e. physical changes in the property insured which result in the property becoming uninsurable, or f. a determination by the commissioner that the continuation of the policy would violate or would place the insurer in violation of this code. Section 65. All notices of cancellation mentioned in the preceding section shall be in writing, mailed or delivered to the named insured at the address shown in the policy, and shall state which of the grounds set forth in Section 64 is relied upon, and be that, upon written request of the named insured, the insurer will furnish the facts on which the cancellation is based. Section 66. In case of insurance other than life, unless the insurer at least 45 days in advance of the end of the policy period mails or delivers to the named insured at the address shown in the policy notice of its intention not to renew the policy or to condition its renewal upon reduction of limits or elimination of coverages, the named insured shall be entitled to renew the policy upon payment of the premium due on the effective date of the renewal. Any policy written for a term of less than 1 year shall be considered as if written for a term of 1 year. Any policy written for a term longer than 1 year or any policy with no fixed expiration date shall be considered as if written for successive policy periods or terms of 1 year. Title 7. Warranties. Section 67. A warranty is either expressed or implied. Section 68. A warranty may relate to the past, the present, the future, or to any or all of these. Section 69. No particular form of words is necessary to create a warranty. Section 70. Without prejudice to Section 51, every express warranty made at or before the execution of a policy must be contained in the policy itself, or in another instrument, signed by the insured and referred to in the policy as making a part of it. Section 71. A statement in a policy of matter relating to the person or thing insured, or to the risk, as a fact, is an express warranty thereof. Section 72. A statement in a policy which imparts that it is intended to do or not to do a thing which materially affects the risk is a warranty that such act or omission shall take place. Section 73. When, before the time arrives for the performance of a warranty relating to the future, a loss insured against happens, or performance becomes unlawful at the place of the contract, or impossible, the omission to fulfill the warranty does not avoid the policy. Section 74. The violation of a material warranty or other material provision of a policy on the part of either party threato entitles the other to rescind. Section 75. A policy may declare that a violation of specified provisions thereof shall avoid it, otherwise the breach of an immaterial provision does not avoid the policy. Section 76. A breach of warranty without fraud merely exonerates an insurer from the time that it occurs, or where it is broken in its inception, prevents the policy from attaching to the risk. Title 8. Premium. Section 77. An insurer is entitled to payment of a premium as soon as the thing insured is exposed to the peril insured against. Notwithstanding any agreement to the contrary, no policy or contract of insurance issued by an insurance company is valid and binding unless and until the premium thereof has been paid, except in the case of a life or an industrial life policy, whenever the grace period provision applies. Section 78. An acknowledgment in a policy or contract of insurance or the receipt of premium is conclusive evidence of its payment, so far as to make the policy binding, notwithstanding any stipulation therein that it shall not be binding until the premium is actually paid. Section 79. A person insured is entitled to a return of premium as follows: to the whole premium, if no part of his interest in the thing insured be exposed to any of the perils insured against, v. where the insurance is made for a definite period of time and the insured surrenders his policy to such portion of the premium as corresponds with the unexpired time at a pro rata rate, unless a short period rate has been agreed upon and appears on the face of the policy, after deducting from the whole premium any claim for loss or damage under the policy which has previously accrued, provided that no holder of a life insurance policy may avail himself of the privileges of this paragraph without sufficient cause as otherwise provided by law. Section 80. If a peril insured against has existed and the insurer has been liable for any period, however short, the insured is not entitled to a return of premiums, so far as that particular risk is concerned. Section 81. A person insured is entitled to a return of the premium when the contract is voidable on account of fraud or misrepresentation of the insurer or of his agent, or on account of facts, the existence of which the insured was ignorant without his fault, or when by any default of the insured other than actual fraud, the insurer never incurred any liability under the policy. Section 82. In case of an overinsurance by several insurers, the insured is entitled to a ratable return of the premium, proportion to the amount by which the aggregate sum insured in all the policies exceeds the insurable value of the thing at risk. Title 9. Loss. Section 83. An agreement not to transfer the claim of the insured against the insurer after the loss has happened is void if made before the loss except as otherwise provided in the case of life insurance. Section 84. Unless otherwise provided by the policy, an insurer is liable for a loss of which the peril insured against was the proximate cause, although a peril not contemplated by the contract may have been a remote cause of the loss, but he is not liable for a loss which the peril insured against was only a remote cause. Section 85. An insurer is liable where the thing insured is rescued from a peril insured against that would otherwise have caused a loss, if, in the course of such rescue, the thing is exposed to a peril not insured against, which permanently deprives the insured of its possession in whole or in part, or where a loss is caused by efforts to rescue the thing insured from a peril insured against. Section 86. Where a peril is especially accepted in a contract of insurance, a loss which would not have occurred but for such peril is thereby accepted although the immediate cause of the loss was a peril which was not accepted. Section 87. An insurer is not liable for a loss caused by the willful act or through the connivance of the insured, but he is not exonerated by the negligence of the insured or of the insurance agents or others. Title 10. Notice of loss. Section 88. In case of loss upon an insurance against fire, an insurer is exonerated if notice thereof be not given to him by an insured or some person entitled to the benefit of the insurance without unnecessary delay. Section 89. When a preliminary proof of loss is required by a policy, the insured is not bound to give such proof as would be necessary in a court of justice, but it is sufficient for him to give the best evidence which he has in his power at the time. Section 90. All defects in a notice of loss or in preliminary proof thereof, which the insured might remedy and which the insurer omits to specify to him without unnecessary delay as grounds of objection, are waived. Section 91. Delay in the presentation to an insurer of notice or proof of loss is waived if caused by any act of him or if he omits to take objection promptly and specifically upon that ground. Section 92. If the policy requires, by way of preliminary proof of loss, the certificate or testimony of a person other than the insured, it is sufficient for the insured to use reasonable diligence to procure it, and in case of the refusal of such person to give it, then to furnish reasonable evidence to the insurer that such refusal was not induced by any just grounds of disbelief in the facts necessary to be certified or testified. Title 11. Double Insurance. Section 93. A double insurance exists where the same person is insured by several insurers separately in respect to the same subject and interest. Section 94. Where the insured is overinsured by double insurance, the insured, unless the policy otherwise provides, may claim payment from the insurers in such order as he may select, up to the amount for which the insurers are severally liable under their respective contracts. Where the policy under which the insured claims is a valued policy, the insured must give credit as against the valuation for any sum received by him under any other policy without regard to the actual value of the subject matter insured. Where the policy under which the insured claims is an unvalued policy, he must give credit as against the full insurable value for any sum received by him under any policy. Where the insured receives any sum in excess of the valuation in the case of valued policies, or of the insurable value in the case of unvalued policies, he must hold such sum in trust for the insurers, according to their right of contribution among themselves. Each insurer is bound, as between himself and the other insurers, to contribute ratably to the loss in proportion to the amount for which he is liable under his contract. Title 12. Reinsurance. Section 95. A contract of reinsurance is one by which an insurer procures a third person to insure him against loss or liability by reason of such original insurance. Section 96. Where an insurer obtains reinsurance, except under automatic reinsurance treaties, he must communicate all the representations of the original insured, and also all the knowledge and information he possesses, whether previously or subsequently acquired, which are material to the risk. Section 97. A reinsurance is presumed to be a contract of indemnity against liability, and not merely against damage. Section 98. The original insured has no interest in a contract of reinsurance. Chapter E. Classes of Insurance. Title I. Marine Insurance. Subtitle 1A. Definition. Section 99. Marine insurance includes 1. Insurance against loss of or damage to a vessel, craft, aircraft, vehicles, goods, freights, cargoes, merchandise, effects, disbursements, profits, monies, securities, choses in action, evidences of debts, valuable papers, bottomry and respondencia interests and all other kinds of property and interests therein, in respect to, pertaining to or in connection with any and all risks or perils of navigation, transit or transportation, or while being assembled, packed, crated, veiled, compressed or similarly prepared for shipment or while awaiting shipment, or during any delays, storage, transshipment, or reshipment incident threato, including war risks, marine builders risks, and all personal property floater risks, the person or property in connection with or pertaining to a marine, inland marine, transit or transportation insurance, including liability for loss of or damage arising out of or in connection with a construction, repair, operation, maintenance or use of the subject matter of such insurance, but not including life insurance or surety bonds nor insurance against loss by reason of bodily injury to any person arising out of ownership, maintenance, or use of automobiles. See precious stones, jewels, jewelry, precious metals, whether in course of transportation or otherwise. See bridges, tunnels and other instrumentalities of transportation and communication excluding buildings, their furniture and furnishings, fixed contents and supplies held in storage, piers, wharves, docks and slips, and other aids to navigation and transportation, including dry docks and marine railways, dams and appurtenant facilities for the control of waterways. 2. Marine protection and indemnity insurance, meaning insurance against legal liability of the insured for loss, damage, or expense incident to ownership, operation, chartering, maintenance, use, repair, or construction of any vessel, craft or instrumentality in use of ocean or inland waterways, including liability of the insured for personal injury, illness or death, or for loss of or damage to the property of another person. Subtitle 1. The insurable interest. Section 100. The owner of a ship has in all cases an insurable interest in it, even when it has been chartered by one who covenants to pay him its value in case of loss, provided that in this case the insurer shall be liable for only that part of the loss which the insured cannot recover from the charterer. Section 101. The insurable interest of the owner of a ship, hypothecated by Lotomry, is only the excess of its value over the amount secured by Lotomry. Section 102. Freightage, in the sense of a policy of marine insurance, signifies all the benefits derived by the owner either from the chartering of the ship or its employment for the carriage of his own goods or those of others. Section 103. The owner of a ship has an insurable interest in expected freightage, which according to the ordinary and probable course of things he would have earned but for the intervention of a peril insured against or other peril incident to the voyage. Section 104. The interest mentioned in the last section exists in case of a charter party when the ship has broken ground on the chartered voyage. If a price is to be paid for the carriage of goods, it exists when they are actually on board, or there is some contract for putting them on board, and both ship and goods are ready for the specified voyage. Section 105. One who has an interest in the thing from which profits are expected to proceed has an insurable interest in the profits. Section 106. The charterer of a ship has an insurable interest in it, to the extent that he is liable to be indemnified by its loss. Subtitle 1C. Concealment. Section 107. In marine insurance, each party is bound to communicate, in addition to what is required by Section 28, all the information which he possesses material to the risk, except such as is mentioned in Section 30, and to state the exact and whole truth in relation to all matters that he represents, or upon inquiry, discloses or assumes to disclose. Section 108. In marine insurance, information of the belief or expectation of a third person in reference to a material fact is material. Section 109. A person insured by a contract of marine insurance is presumed to have knowledge, at the time of insuring, of a prior loss, if the information might possibly have reached him in the usual mode of transmission and at the usual rate of communication. Section 110. A concealment in a marine insurance, in respect to any of the following matters, does not vitiate the entire contract, but merely exonerates the insurer from a loss resulting from the risk concealed of the national character of the insured, v. the liability of the thing insured to capture and detention, c. the liability to seizure from breach of foreign laws of trade, d. the want of necessary documents, e. the use of false and simulated papers. Subtitle 1D. Representation. Section 111. If a representation by a person insured by a contract of marine insurance is intentionally false in any material respect, or in respect of any fact on which the character and nature of the risk depends, the insurer may rescind the entire contract. Section 112. The eventual falsity of a representation as to expectation does not, in the absence of fraud, avoid a contract of marine insurance. Subtitle 1E. Implied warranties. Section 113. In every marine insurance upon a ship or freight, or freightage, or upon anything which is the subject of marine insurance, a warranty is implied that the ship is seaworthy. Section 114. A ship is seaworthy when reasonably fit to perform the service and to encounter the ordinary perils of the voyage, contemplated by the parties to the policy. Section 115. An implied warranty of seaworthiness is complied with if the ship be seaworthy at the time of the commencement of the risk, except in the following cases. When the insurance is made for a specified length of time, the implied warranty is not complied with unless the ship be seaworthy at the commencement of every voyage it undertakes during that time. When the insurance is upon the cargo which, by the terms of the policy, description of the voyage, or established custom of the trade, is to be transhipped at an intermediate port, the implied warranty is not complied with unless each vessel upon which the cargo is shipped, or transhipped, be seaworthy at the commencement of each particular voyage. Section 116. A warranty of seaworthiness extends not only to the condition of the structure of the ship itself, but requires that it be properly laden and provided with a competent master, a sufficient number of competent officers and seamen, and the requisite appurtenances and equipment, such as ballasts, cables and anchors, cordage and sails, food, water, fuel and lights, and other necessary or proper stores and implements for the voyage. Section 117. Where different portions of the voyage, contemplated by a policy, differ in respect to the things requisite to make the ship seaworthy, therefore, a warranty of seaworthiness is complied with if, at the commencement of each portion, the ship is seaworthy with reference to that portion. Section 118. When the ship becomes unseaworthy during the voyage to which an insurance relates, an unreasonable delay in repairing the defect exonerates the insurer on ship or ship owner's interest from liability from any loss arising therefrom. Section 119. A ship which is seaworthy for the purpose of an insurance upon the ship may, nevertheless, by reason of being unfitted to receive the cargo, be unseaworthy for the purpose of the insurance upon the cargo. Section 120. Where the nationality or neutrality of a ship or cargo is expressly warranted, it is implied that the ship will carry the requisite documents to show such nationality or neutrality, and that it will not carry any documents which cast reasonable suspicion therein. Subtitle 1F. The Voyage and Deviation. Section 121. When the voyage, contemplated by a marine insurance policy, is described by the places of beginning and ending, the voyage insured in one which conforms to the course of sailing, fixed by mercantile usage between those places. Section 122. If the course of sailing is not fixed by mercantile usage, the voyage insured by a marine insurance policy is that way between the places specified, which to a master of ordinary skill and discretion would mean the most natural, direct and advantageous. Section 123. Deviation is a departure from the course of the voyage insured, mentioned in the last two sections, or an unreasonable delay in pursuing the voyage or the commencement of an entirely different voyage. Section 124. A deviation is proper when caused by circumstances over which neither the master nor the owner of the ship has any control, when necessary to comply with a warranty or to avoid a peril, whether or not the peril is insured against, C. When made in good faith and upon reasonable grounds of belief in its necessity to avoid a peril, or D. When made in good faith for the purpose of saving human life or relieving another vessel in distress. Section 125. Every deviation not specified in the last section is improper. Section 126. An insurer is not liable for any loss happening to the thing insured subsequent to an improper deviation. Subtitle 1G. Loss. Section 127. A loss may be either total or partial. Section 128. Every loss which is not total is partial. Section 129. A total loss may be either actual or constructive. Section 130. An actual total loss is caused by the total destruction of the thing insured, be the irretrievable loss of the thing by sinking or by being broken up, C. Any damage to the thing which renders it valueless to the owner for the purpose for which he held it, or D. Any other event which effectively deprives the owner of the possession at the port of destination of the thing insured. Section 131. A constructive total loss is one which gives to a person insured a right to abandon under Section 139. Section 132. An actual loss may be presumed from the continued absence of a ship without being heard of. The length of time which is sufficient to raise this presumption depends on the circumstances of the case. Section 133. When a ship is prevented at an intermediate port from completing the voyage by the perils insured against, the liability of a marine insurer on the cargo continues after they are thus reshipped. Nothing in this section shall prevent an insurer from requiring an additional premium if the hazard be increased by this extension of liability. Section 134. In addition to the liability mentioned in the last section, a marine insurer is bound for damages, expenses of discharging, storage, reshipment, extra freightage, and all other expenses incurred in saving cargo reshipped pursuant to the last section up to the amount insured. Nothing in this or in the preceding section shall render a marine insurer liable for any amount in excess of the insured value or, if there be none, of the insurable value. Section 135. Upon an actual total loss, a person insured is entitled to payment without notice of abandonment. Section 136. Where it has been agreed that an insurance upon a particular thing or class of things shall be free from particular average, a marine insurer is not liable for any particular average loss, not depriving the insured of the possession at the port of destination of the whole of such thing or class of things, even though it becomes entirely worthless, but such insurer is liable for his proportion of all general average loss assessed upon the thing insured. Section 137. An insurance, confined in terms to an actual loss, does not cover a constructive total loss, but covers any loss which necessarily results in depriving the insured of the possession at the port of destination of the entire thing insured. Subtitle 1H. Abandonment. Section 138. Abandonment in marine insurance is the act of the insured by which, after a constructive total loss, he declares the relinquishment to the insurer of his interest in the thing insured. Section 139. A person insured by a contract of marine insurance may abandon the thing insured or any particular portion thereof separately valued by the policy or otherwise separately insured and recover for a total loss thereof when the cause of the loss is a peril insured against, if more than 3/4 thereof in value is actually lost or would have to be expended to recover it from the peril, if it is injured to such an extent as to reduce its value more than 3/4. See if the thing insured is a ship, and the contemplated voyage cannot be lawfully performed without incurring either an expense to the insured of more than 3/4 the value of the thing abandoned or a risk which a prudent man would not take under the circumstances, or d. if the thing insured, being cargo or freightage, and the voyage cannot be performed, nor another ship procured by the master within a reasonable time and with reasonable diligence, to forward the cargo without incurring the like expense or risk mentioned in the preceding subparagraph. But freightage cannot in any case be abandoned unless the ship is also abandoned. Section 140. An abandonment must be neither partial nor conditional. Section 141. An abandonment must be made within a reasonable time after receipt of reliable information of a loss, but where the information is of a doubtful character, the insured is entitled to a reasonable time to make inquiry. Section 142. Where the information upon which an abandonment has been made proves incorrect, or the thing insured was so far restored when the abandonment was made that there was then in fact no total loss, the abandonment becomes ineffectual. Section 143. Abandonment is made by giving notice thereof to the insurer, which may be done orally or in writing, provided that if the notice be done orally, a written notice of such abandonment shall be submitted within 7 days from such oral notice. Section 144. A notice of abandonment must be explicit and must specify the particular cause of the abandonment, but need state only enough to show that there is probable cause therefore, and need not be accompanied with proof of interest or loss. Section 145. An abandonment can be sustained only upon the cause specified in the notice thereof. Section 146. An abandonment is equivalent to a transfer by the insured of his interest to the insurer with all the chances of recovery and indemnity. Section 147. If a marine insurer pays for a loss as if it were an actual total loss, he is entitled to whatever may remain of the thing insured, or its proceeds or salvage, as if there had been a formal abandonment. Section 148. Upon an abandonment, acts done in good faith by those who were agents of the insured in respect to the thing insured, subsequent to the loss, are at the risk of the insurer and for his benefit. Section 149. Where notice of abandonment is properly given, the rights of the insured are not prejudiced by the fact that the insurer refuses to accept the abandonment. Section 150. The acceptance of an abandonment may be either express or implied from the conduct of the insurer. The mere silence of the insurer for an unreasonable length of time after notice shall be construed as an acceptance. Section 151. The acceptance of an abandonment, whether express or implied, is conclusive upon the parties, and admits the loss and the sufficiency of the abandonment. Section 152. An abandonment once made and accepted is irrevocable unless the ground upon which it was made proves to be unfounded. Section 153. On an accepted abandonment of a ship, freightage earned previous to the loss belongs to the insurer of said freightage, but freightage subsequently earned belongs to the insurer of the ship. Section 154. If an insurer refuses to accept a valid abandonment, he is liable as upon actual total loss, deducting from the amount any proceeds of the thing insured which may have come to the hands of the insured. Section 155. If a person insured omits to abandon, he may nevertheless recover his actual loss. Subtitle 1. Measure of indemnity. Section 156. A valuation in a policy of marine insurance, inconclusive between the parties threato in the adjustment of either a partial or total loss, if the insured has some interest at risk, and there is no fraud on his part, except that when a thing has been hypothecated by lottery or respondencia before its insurance, and without the knowledge of the person actually procuring the insurance, he may show the real value. But a valuation fraudulent in fact entitles the insurer to rescind the contract. Section 157. A marine insurer is liable upon a partial loss only for such proportion of the amount insured by him as the loss bears to the value of the whole interest of the insured in the property insured. Section 158. Where profits are separately insured in a contract of marine insurance, the insured is entitled to recover, in case of loss, a proportion of such profits equivalent to the proportion which the value of the property lost bears to the value of the whole. Section 159. In case of a valued policy of marine insurance, on freightage or cargo, if a part only of the subject is exposed to the risk, the valuation applies only in proportion to such part. Section 160. When profits are valued and insured by a contract of marine insurance, a loss of them is conclusively presumed from a loss of the property out of which they are expected to arise, and the valuation fixes their amount. Section 161. In estimating a loss under an open policy of marine insurance, the following rules are to be observed. The value of a ship is its value at the beginning of the risk, including all articles or charges which add to its permanent value or which are necessary to prepare it for the voyage insured. The value of the cargo is its actual cost to the insured when laden on board, or where the cost cannot be ascertained, its market value at the time and place of lading, adding the charges incurred in purchasing and placing it on board, but without reference to any loss incurred in raising money for its purchase, or to any drawback on its exportation, or to the fluctuation of the market at the port of destination, or to expenses incurred on the way or on arrival. The value of freightage is the gross freightage, exclusive of primage, without reference to the cost of earning it, and the cost of insurance is in each case to be added to the value thus estimated. Section 162. If cargo insured against partial loss arrives at the port of destination in a damaged condition, the loss of the insured is deemed to be the same proportion of the value which the market price at that port of the thing so damaged bears to the market price it would have brought if sound. Section 163. A marine insurer is liable for all the expenses attendant upon a loss, which forces the ship into port to be repaired, and where it is stipulated in the policy that the insured shall labor for the recovery of the property, the insurer is liable for the expense incurred thereby, such expense, in either case, being in addition to a total loss, if that afterwards occurs. Section 164. A marine insurer is liable for a loss falling upon the insured through a contribution in respect to the thing insured required to be made by him towards the general average loss called for by a peril insured against, provided that the liability of the insurer shall be limited to the proportion of contribution attaching to his policy value, where this is less than the contributing value of the thing insured. Section 165. When a person insured by a contract of marine insurance has a demand against others for contribution, he may claim the whole loss from the insurer, subrogating him to his own right to contribution. But no such claim can be made upon the insurer after the separation of the interests liable to the contribution, nor when the insured, having the right and opportunity to enforce the contribution from others, has neglected or waived the exercise of that right. Section 166. In the case of a partial loss of ship or its equipment, the old materials are to be applied towards payment for the new. Unless otherwise stipulated in the policy, a marine insurer is liable for only 2/3 of the remaining cost of repairs after such deduction, except that anchors must be paid in full. Title II. Fire Insurance. Section 167. As used in this code, the term fire insurance shall include insurance against loss by fire, lightning, windstorm, tornado or earthquake and other allied risks, when such risks are covered by extension to fire insurance policies or under separate policies. Section 168. An alteration in the use or condition of a thing insured from that to which it is limited by the policy made without the consent of the insurer, by means within the control of the insured, and increasing the risks, entitles an insurer to rescind a contract of fire insurance. Section 169. An alteration in the use or condition of a thing insured from that to which it is limited by the policy, which does not increase the risk, does not affect the contract of fire insurance. Shanrivel's Virtual Law Library. Section 170. A contract of fire insurance is not affected by any act of the insured subsequent to the execution of the policy, which does not violate its provisions, even though it increases the risk and is the cause of the loss. Section 171. If there is no valuation in the policy, the measure of indemnity in an insurance against fire is the expense it would be to the insured at the time of the commencement of the fire to replace the thing lost or injured in the condition in which at the time of the injury, but if there is a valuation in a policy of fire insurance, the effect shall be the same as in a policy of marine insurance. Section 172. Whenever the insured desires to have a valuation named in his policy insuring any building or structure against fire, he may require such building or structure to be examined by an independent appraiser, and the value of the insured's interest therein may then be fixed as between the insurer and the insured. The cost of such examination shall be paid for by the insured. A clause shall be inserted in such policy stating substantially that the value of the insured's interest in such building or structure has been thus fixed. In the absence of any change, increasing the risk without the consent of the insurer or a fraud on the part of the insured, then in case of a total loss under such policy, the whole amount so insured upon the insured's interest in such building or structure, as stated in the policy upon which the insurers have received the premium, shall be paid, and in case of a partial loss the full amount of the partial loss shall be so paid, and in case there are two or more policies covering the insured's interest therein, each policy shall contribute pro rata to the payment of such whole or partial loss. But in no case shall the insurer be required to pay more than the amount thus stated in such policy. This section shall not prevent the parties from stipulating in such policies concerning the repairing, rebuilding or replacing of buildings or structures wholly or partially damaged or destroyed. Section 173. No policy of fire insurance shall be pledged, hypothecated, or transferred to any person, firm or company who acts as agent for or otherwise represents the issuing company, and any such pledge, hypothecation, or transfer hereafter made shall be void and of no effect, insofar as it may affect other creditors of the insured. Title 3. Casualty Insurance. Section 174. Casualty insurance is insurance covering loss or liability arising from accident or mishap, excluding certain types of loss, which by law or custom are considered as falling exclusively within the scope of other types of insurance such as fire or marine. It includes, but is not limited to, employer's liability insurance, motor vehicle liability insurance, plate glass insurance, burglary and theft insurance, personal accident and health insurance as written by non-life insurance companies, and other substantially similar kinds of insurance. Title 4. Suretyship. Section 175. A contract of suretyship is an agreement whereby a party, called the surety, guarantees the performance, by another party, called the principal or obligor of an obligation or undertaking in favor of a third party, called the obligee. It includes official recognizances, stipulations, bonds or undertakings issued by any company by virtue of and under the provisions of Act No. 536, as amended by Act No. 2206. Section 176. The liability of a surety or sureties shall be joint and several with the obligor and shall be limited to the amount of the bond. It is determined strictly by the terms of the contract of suretyship in relation to the principal contract between the obligor and the obligee, as amended by Presidential Decree No. 1455. Section 177. The surety is entitled to payment of the premium as soon as the contract of suretyship or bond is perfected and delivered to the obligor. No contract of suretyship or bonding shall be valid and binding unless and until the premium therefore has been paid, except where the obligee has accepted the bond, in which case the bond becomes valid and enforceable irrespective of whether or not the premium has been paid by the obligor to the surety, provided that if the contract of suretyship or bond is not accepted by or filed with the obligee, the surety shall collect only reasonable amount, not exceeding 50% of the premium due theory and as service fee plus the cost of stamps or other taxes imposed for the issuance of the contract or bond, provided, however, that if the non-acceptance of the bond be due to the fault or negligence of the surety, no such service fee, stamps or taxes shall be collected. In the case of a continuing bond, the obligor shall pay the subsequent annual premium as it falls due until the contract of suretyship is cancelled by the obligee or by the commissioner or by a court of competent jurisdiction, as the case may be. Shamraville's Virtual Law Library, Section 178. Pertinent provisions of the Civil Code of the Philippines shall be applied in a suppletory character whenever necessary in interpreting the provisions of the contract of suretyship. Title 5. Life Insurance. Section 179. Life insurance is insurance on human lives and insurance pertaining to it or connected therewith. Section 180. An insurance upon life may be made payable on the death of a person or on his surviving a specified period or otherwise contingently on the continuance or cessation of life. Every contract or pledge for the payment of endowments or annuities shall be considered a life insurance contract for purpose of this code. In the absence of a judicial guardian, the father, or in the latter's absence or incapacity, the mother, or any minor, who is an insured or a beneficiary under a contract of life, health or accident insurance, may exercise, in behalf of said minor, any right under the policy, without necessity of court authority or the giving of a bond, where the interest of the minor, in the particular act involved does not exceed 20,000 pesos. Such right may include, but shall not be limited to, obtaining a policy loan, surrendering the policy, receiving the proceeds of the policy, and giving the minor's consent to any transaction on the policy. Section 188. The insurer in a life insurance contract shall be liable in case of suicides only when it is committed after the policy has been in force for a period of 2 years from the date of its issue or of its last reinstatement, unless the policy provides a shorter period, provided, however, that suicide committed in the state of insanity shall be compensable regardless of the date of commission, as amended by Vatican Convention the LG. 874. Section 181. A policy of insurance upon life or health may pass by transfer, will or succession to any person, whether he has an insurable interest or not, and such person may recover upon it whatever the insured might have recovered. Section 182. Notice to an insurer of a transfer or bequest thereof is not necessary to preserve the validity of a policy of insurance upon life or health, unless thereby expressly required. Section 183. Unless the interest of a person insured is susceptible of exact pecuniary measurement, the measure of indemnity under a policy of insurance upon life or health is the sum fixed in the policy. Chapter III. The Business of Insurance. Title 1. Insurance Companies, Organization, Capitalization and Authorization. Section 184. For purposes of this code, the term insurer or insurance company shall include all individuals, partnerships, associations, or corporations, including government-owned or controlled corporations or entities, engaged as principals in the insurance business, excepting mutual benefit associations. Unless the context otherwise requires, the terms shall also include professional reinsurers defined in Section 280. Domestic company shall include companies formed, organized, or existing under the laws of the Philippines. Foreign company, when used without limitation, shall include companies formed, organized, or existing under any laws other than those of the Philippines. Section 185. Corporations formed or organized to save any person or persons or other corporations harmless from loss, damage, or liability arising from any unknown or future or contingent event, or to indemnify or to compensate any person or persons or other corporations for any such loss, damage, or liability, or to guarantee the performance of or compliance with contractual obligations or the payment of debt of others, shall be known as insurance corporations. The provisions of the corporation law shall apply to all insurance corporations now or hereafter engaged in business in the Philippines, insofar as they do not conflict with the provisions of this chapter. Section 186. No person, partnership, or association of persons shall transact any insurance business in the Philippines except as agent of a person or corporation authorized to do the business of insurance in the Philippines, unless possessed of the capital and assets required of an insurance corporation doing the same kind of business in the Philippines and invested in the same manner, nor unless the commissioner shall have granted to him or them a certificate to the effect that he or they have complied with all the provisions of law which an insurance corporation doing business in the Philippines is required to observe. Every person, partnership, or association receiving any such certificate of authority shall be subject to the insurance laws of the Philippines and to the jurisdiction and supervision of the commissioner in the same manner as if an insurance corporation authorized by the laws of the Philippines to engage in the business of insurance specified in the certificate. Section 187. No insurance company shall transact any insurance business in the Philippines until after it shall have obtained a certificate of authority for that purpose from the commissioner upon application, therefore, and payment by the company concerned of the fees hereinafter prescribed. The commissioner may refuse to issue a certificate of authority to any insurance company if, in his judgment, such refusal will best promote the interest of the people of this country. No such certificate of authority shall be granted to any such company until the commissioner shall have satisfied himself by such examination as he may make and such evidence as he may require that such company is qualified by the laws of the Philippines to transact business therein, that the grant of such authority appears to be justified in the light of economic requirements, and that the direction and administration, as well as the integrity and responsibility of the organizers and administrators, the financial organization and the amount of capital, notwithstanding the provisions of Section 188, reasonably assure the safety of the interests of the policyholders and the public. In order to maintain the quality of the management of the insurance companies and afford better protection to policyholders and the public in general, any person of good moral character, unquestioned integrity and recognized competence, may be elected or appointed director or officer of insurance companies. The Commissioner shall prescribe the qualifications of the executive officers and other key officials of insurance companies, for purposes of this section. No person shall concurrently be a director and/or officer of an insurance company and an adjustment company. Incumbent directors and/or officers affected by the above provisions are hereby allowed to hold on to their positions until the end of their terms or 2 years from the effectivity of this decree, whichever is shorter. Before issuing such certificate of authority, the Commissioner must be satisfied that the name of the company is not that of any other known company transacting a similar business in the Philippines, or a name so similar as to be calculated to mislead the public. Such certificate of authority shall expire on the last day of June of each year and shall be renewed annually if the company is continuing to comply with the provisions of this code or the circulars, instructions, rulings or decisions of the Commissioner. Every company receiving any such certificates of authority shall be subject to the provisions of this code and other related laws and to the jurisdiction and supervision of the Commissioner. No insurance company may be authorized to transact in the Philippines the business of life and non-life insurance concurrently unless specifically authorized to do so, provided that the terms life and non-life insurance shall be deemed to include health, accident and disability insurance. No insurance company shall have equity in an adjustment company, and neither shall an adjustment company have an equity in an insurance company. Insurance companies and adjustment companies presently affected by the above provision shall have 2 years from the effectivity of this decree within which to divest of their stock holdings, as amended by Presidential Decree No. 1455. Section 188. Except as provided in Section 281, no domestic insurance company shall, in a stock corporation, engage in business in the Philippines, unless possessed of a paid-up capital stock equal to at least 5 million pesos, provided that a domestic insurance company already doing business in the Philippines with a paid-up capital stock, which is less than 5 million pesos, shall have a paid-up capital stock of at least 3 million pesos by December 31, 1978, 4 million pesos by December 31, 1979, and 5 million pesos by December 31, 1980. Provided, further, that the Secretary of Finance may, upon recommendation of the Insurance Commissioner, increase such minimum paid-up capital stock requirement, under such terms and conditions as he may impose, to an amount which, in his opinion, would reasonably assure the safety of the interests of the policyholders and the public. Shamrable's Virtual Law Library. The Commissioner may, as a pre-licensing requirement of a new insurance company, in addition to the paid-up capital stock, require the stockholders to pay in cash to the company, in proportion to their subscription interests, a contributed surplus fund of not less than 1 million pesos, in the case of a life insurance company, or not less than 500,000 pesos, in the case of an insurance company other than life. He may also require such company to submit to him a business plan showing the company's estimated receipts and disbursements, as well as the basis therefor, for the next succeeding 3 years. If organized as a mutual company, in lieu of such capital stock, it must have available cash assets of at least 5 million pesos above all liabilities, for losses reported, expenses, taxes, legal reserve, and the insurance of all outstanding risks, and the contributed surplus fund equal to the amounts required of stock corporations. A stock insurance company doing business in the Philippines may, subject to the pertinent law and regulations which now are and hereafter may be in force, alter its organization and transform itself into a mutual insurance company, as amended by Presidential Decree No. 1455. Section 189. Every company must, before engaging in the business of insurance in the Philippines, file with a commissioner the following: a certified copy of the last annual statement or a verified financial statement exhibiting the condition and affairs of such company, be if incorporated under the laws of the Philippines, a copy of the articles of incorporation and bylaws, and any amendments to either, certified by the Securities and Exchange Commission to be a copy of that which is filed in its office, see if incorporated under any laws other than those of the Philippines, a certificate from the Securities and Exchange Commission showing that it is duly registered in the Mercantile Registry of that Commission in accordance with the corporation law. A copy of the Articles of Incorporation and bylaws, and any amendments to either, if organized or formed under any law requiring such to be filed, duly certified by the officer having the custody of same, or if not so organized, a copy of the law, charter or deed of settlement under which the deed of organization is made, duly certified by the proper custodian thereof, or proved by affidavit to be a copy, also a certificate under the hand and seal of the proper officer of such state or country having supervision of insurance business therein, if any there be, that such corporation or company is organized under the laws of such state or country, with the amount of capital stock or assets and legal reserve required by this code, be if not incorporated in a foreign domicile, aside from the certificate mentioned in paragraph C of this section, a certificate setting forth the nature and character of the business, the location of the principal office, the name of the individual or names of the persons composing the partnership or association, the amount of actual capital employed or to be employed therein, and the names of all officers and persons by whom the business is or may be managed. The certificate must be verified by the affidavit of the chief officer, secretary, agent, or manager of the company, and if there are any written articles of agreement of the company, a copy thereof must be accompany such certificate. Section 190. The Commissioner must require as a condition precedent to the transaction of insurance business in the Philippines, by any foreign insurance company, that such company file in his office a written power of attorney designating some person who shall be a resident of the Philippines as its general agent, on whom any notice provided by law or by any insurance policy, proof of loss, summons and other legal processes, may be served in all actions or other legal proceedings against such company, and consenting that service upon such general agent shall be admitted and held as valid as if served upon the foreign company at its home office. Any such foreign company shall, as further condition precedent to the transaction of insurance business in the Philippines, make and file with a commissioner an agreement or stipulation executed by the proper authorities of said company in form and substance as follows. The name of company does hereby stipulate and agree in consideration of the permission granted by the insurance commissioner to transact business in the Philippines, that if at any time said company shall leave the Philippines, or cease to transact business therein, or shall be without any agent in the Philippines, on whom any notice, proof of loss, summons, or legal process may be served, then in any action or proceeding arising out any business or transaction which occurred in the Philippines, service of any notice, provided by law or insurance policy, proof of loss, summons, or other legal process may be made upon the insurance commissioner, shall have the same force and effect as if made upon the company. Whenever such service of notice, proof of loss, summons, or other legal process shall be made upon the commission, he must, within 10 days thereafter, transmit by mail, postage paid, a copy of such notice, proof of loss, summons, or other legal process to the company at its home or principal office. The sending of such copy by the commissioner shall be a necessary part of the service of the notice, proof of loss, or other legal process. Section 191. No insurance company, organized or existing under the government or laws other than those of the Philippines shall engage in business in the Philippines, unless possessed of paid up unimpaired capital or assets and reserves not less than that herein required of domestic insurance companies, nor until it shall have deposited with a commissioner, for the benefit and security of the policyholders and creditors of such company in the Philippines, securities satisfactory to the commissioner consisting of good securities of of the Philippines, including new issues of stock of registered enterprises, as this term is defined in Republic Act No. 5186, otherwise known as the Investment Incentive Act, as amended, to the actual market value of not less than the minimum paid-up capital required of domestic insurance companies, provided that at least 50% of such securities shall consist of bonds or other evidences of debt of the government of the Philippines, its political subdivisions and instrumentalities, or of government-owned or controlled corporations and entities, including the central bank. The total investment of a foreign insurance company in any registered enterprise shall not exceed 20% of the net worth of said foreign insurance company nor 20% of the capital of the registered enterprise, unless previously authorized in writing by the Commissioner. For purposes of this code, the net worth of a foreign insurance company shall refer only to its net worth in the Philippines. Section 192. The Commissioner shall hold the securities deposited as aforesaid for the benefit and security of all the policyholders of the company depositing the same, but so as long as the company is solvent, permit the company to collect the interest or dividends on the securities so deposited, and, from time to time, with his assent, to withdraw any of such securities, upon depositing with said commission or other like securities, the market value of which shall be equal to the market value of such as may be withdrawn. In the event of any company ceasing to do business in the Philippines, the securities deposited as aforesaid shall be returned upon the company's making application, therefore and proving to the satisfaction of the Commissioner that it has no further liability under any of its policies in the Philippines. Section 193. Every foreign company doing business in the Philippines shall set aside an amount corresponding to the legal reserves of the policies written in the Philippines and invest and keep the same therein in accordance with the provisions of this section. The legal reserve therein required to be set aside shall be invested only in the classes of the Philippine securities described in Section 200, provided, however, that no investment in stocks or bonds of any single entity shall, in the aggregate, exceed 20% of the net worth of the investing company or 20% of the capital of the issuing company, whichever is the lesser, unless otherwise approved in writing by the Commissioner. The securities, purchased and kept in the Philippines under this section, shall not be sent out of the territorial jurisdiction of the Philippines without the written consent of the Commissioner. Title 2. Margin of Insolvency. Section 194. An insurance company doing business in the Philippines shall at all times maintain a margin of solvency which shall be in excess of the value of its submitted assets exclusive of its paid-up capital in the case of a domestic company, or in excess of the value of its submitted assets in the Philippines exclusive of its security deposits in the case of a foreign company over the amount of its liabilities, unearned premium and reinsurance reserves in the Philippines of at least 2 per mil of the total amount of its insurance in force as of the preceding calendar year on all policies except term insurance in the case of a life insurance company, or of at least 10% of the total amount of its net premium written during the preceding calendar year in the case of a company other than a life insurance company, provided that in either case such margin shall in no event be less than 500,000 pesos, and provided further that the term paid-up capital shall not include contributed surplus and capital paid in excess of par value. Such assets, liabilities and reserves shall exclude assets, liabilities and reserves included in separate accounts established in accordance with Section 237. Whenever the aforementioned margin be found to be less than that herein required to be maintained, the Commissioner shall forthwith direct the company to make good any such deficiency by cash, to be contributed by all stockholders of record in proportion to their respective interest, and paid to the treasurer of the company within 15 days from receipt of the order, provided that the company in the interim shall not be permitted to take any new risk of any kind or character unless and until it make good any such deficiency, provided further that a stockholder who aside from paying the contribution due from him pays the contribution due from the another stockholder by reason of the failure or refusal of a letter to do so, shall have a lien on the certificates of stock of the insurance company concerned appearing in its books in the name of the defaulting stockholder on the date of default, as well as on any interests or dividends that have accrued or will accrue to the said certificates of stock until the corresponding payment or reimbursement is made by the defaulting stockholder, as amended by Presidential Decree Number 1455. Section 195. No domestic insurance corporation shall declare or distribute any dividend on its outstanding stocks except from profits attested in a sworn statement to the Commissioner by the President or Treasurer of the corporation to be remaining on hand after retaining unimpaired the entire paid-up capital stock, via the margin of solvency required by Section 194. C. In the case of life insurance corporation, the legal reserve fund required by Section 211. D. In the case of corporations other than life, the legal reserve fund required by Section 213. E. A sum sufficient to pay all net losses reported or in the course of settlement and all liabilities for expenses and taxes. Any dividend, declared or distributed under the preceding paragraph, shall be reported to the Commissioner within 30 days after such declaration or distribution. If the Commissioner finds that any such corporation has declared or distributed any such dividend in violation of this section, he may order such corporation to cease and desist from doing business until the amount of such dividend or the portion thereof, in excess of the amount allowed under this section, has been restored to said corporation. Title 3. Assets. Section 196. In any determination of the financial condition of any insurance company doing business in the Philippines, there shall be allowed and admitted as assets only such assets owned by the insurance company concerned and which consist of 1. Cash in the possession of the insurance company or in transit under its control, and the true and duly verified balance of any deposit of such company in a financially sound commercial bank or trust company. 2. Investments in securities, including money market instruments, and in real property, acquired or held in accordance with and subject to the applicable provisions of this code and the income realized therefrom or accrued therein. 3. Loans granted by the insurance company, concerned to the extent of that portion thereof adequately secured by non-speculative assets, with readily realizable values, in accordance with and subject to the limitations imposed by applicable provisions of this code. 4. Policy loans and other policy assets and liens on policies, contracts or certificates of a life insurance company in an amount not exceeding legal reserves and other policy liabilities, carried on each individual life insurance policy, contract or certificate. 5. The net amount of uncollected and deferred premiums and annuity considerations in the case of a life insurance company which carries the full mean tabular reserve liability. 6. Reinsurance recoverable by the ceding insurer from an insurer authorized to transact business in this country, the full amount thereof, or b. from an insurer not authorized in this country in an amount not exceeding the liabilities carried by the ceding insurer for amounts withheld under a reinsurance treaty with such unauthorized insurer as security for the payment of obligations thereunder if such funds are held subject to withdrawal by and under the control of the ceding insurer. The Commissioner may prescribe the conditions under which the ceding insurer may be allowed credit as an asset or as a deduction from loss and unearned premium reserves for reinsurance recoverable from an insurer not authorized in this country but which presents satisfactory evidence that it meets the applicable standards of solvency required in this country. 7. Funds withheld by a ceding insurer under a reinsurance treaty, provided reserves for unpaid losses and unearned premiums are adequately provided. 8. Deposits or amounts recoverable from underwriting associations, syndicates and reinsurance funds, or from any suspended banking institution, to the extent deemed by the Commissioner to be available for the payment of losses and claims and values to be determined by him. 9. Electronic data processing machines, as may be authorized by the Commissioner to be acquired by the insurance company concerned, the acquisition cost of which to be amortized in equal annual amounts within a period of 5 years from the date of acquisition thereof. 10. Other assets, not inconsistent with the provisions of paragraphs 1 to 9 herewith, which are deemed by the Commissioner to be readily realizable and available for the payment of losses and claims at values to be determined by him. Section 197. In addition to such assets as the Commissioner may from time to time determine to be non-admitted assets of insurance companies doing business in the Philippines, the following assets shall in no case be allowed as admitted assets of an insurance company doing business in the Philippines in any determination of its financial condition. 1. Goodwill, trade names, and other like intangible assets. 2. Repaid or deferred charges for expenses and commissions paid by such insurance company. 3. Advances to officers other than policy loans, which are not adequately secured and which are not previously authorized by the Commissioner, as well as advances to employees, agents, and other persons on mere personal security. 4. Shares of stock of such insurance company owned by it, or any equity therein, as well as loans secured thereby, or any proportionate interest in such shares of stock through the ownership by such insurance company of an interest in another corporation or business unit. 5. Furniture, furnishing, fixtures, safes, equipment, library, stationery, literature, and supplies. 6. Items of bank credits representing checks, drafts or notes, returned unpaid after the date of statement. 7. The amount, if any, by which the aggregate value of investments as carried in the ledger assets of such insurance company exceeds the aggregate value thereof, as determined in accordance with the provisions of this code or the rules of the Commissioner. All non-admitted assets and all other assets of doubtful value or character included as ledger or non-ledger assets in any statement submitted by an insurance company to the Commissioner or in any insurance examiner's report to him shall also be reported to the extent of the value, disallowed as deductions from the gross assets of such insurance company, except where the Commissioner permits a reserve to be carried among the liabilities of such insurance company in lieu of any such deduction. Title 4. Investments. Section 198. No insurance company shall loan any of its money or deposits to any person, corporation or association, except upon first mortgage or deeds of trust of unencumbered, improved or unimproved real estate, including condominiums, in cities and centers of population of municipalities in the Philippines when the amount of such loan is not in excess of 70% of the market value of such real estate, or upon the security of first mortgages or deeds of trust of actually cultivated, improved and unencumbered agricultural lands in the Philippines when the amount of such loan is not in excess of 40% of the market value of such land, or upon the purchase money mortgages or like securities received by it upon the sale or exchange of real property acquired pursuant to sections 200 and 202, or upon bonds or other evidences of debt of the government of the Philippines or its political subdivisions authorized by law to issue bonds, or upon bonds or other evidences of debt of government-owned or controlled corporations and instrumentalities including the central bank, or upon obligations issued or guaranteed by the International Bank for Reconstruction and Development, or upon stocks, bonds or other evidences of debt as are specified in Section 200. A life insurance company, however, may lend to any of its policyholders upon the security of the value of its policy such sum as may be determined pursuant to the provisions of the policy. Loans granted upon the security of real estate for a period longer than 5 years shall be amortized in monthly, quarterly, semi-annual or annual installments, provided that no such loans shall have a maturity in excess of 20 years. The phrase, improved real estate, used above is hereby defined to mean land with permanent building or buildings, erected or being erected therein. except as otherwise approved by the Commissioner. In case the building or buildings on land do not belong to the owner of the latter, no loan shall be granted on the security of the real estate in question, unless both the owner of the building or buildings and the owner of the land sign the deed of mortgage, and unless the owner of the land is the government of the Philippines or one of its political subdivisions, in which event the owner is not required to sign the deed of mortgage. Section 199. No loan by any insurance company on the security of real estate shall be made unless the title to such real estate shall have first been registered in accordance with the existing Land Registration Act, or shall be a duly registered, or have been previously registered under the provisions of the existing mortgage law. Section 200. One, an insurance company may purchase, hold, own and convey such property, real and personal, as may have been mortgaged, pledged, or conveyed to it in good faith, in trust for its benefit, by reason of money loaned by it in pursuance of the regular business of the company, and such real or personal property as may have been purchased by it at sales under pledges, mortgages or deeds of trust, for its benefit on account of money loaned by it, and such real and personal property as may have been conveyed to it by borrowers in satisfaction and discharge of loans made by the company to them, provided, however, that any real estate purchased by an insurance company in payment or by reason of any loan made by it shall be sold by the company within 20 years after the title thereto has been vested in it. 2. An insurance company may purchase, hold, own and convey real and personal property as follows: a lot with building theory in which the company conducts and carries on its business. B. Bonds or other evidences of debt of the government of the Philippines or its political subdivisions authorized by law to issue bonds at the reasonable market value thereof. C. Bonds or other evidences of debt of the government-owned or controlled corporations and entities, including the central bank. D. Bonds, debentures or other evidences of indebtedness of any solvent corporations or institution created or existing under the laws of the Philippines, provided, however, that the issuing, assuming or guaranteeing entity or its predecessors shall not have defaulted in the payment of interest on any of its securities, and that during each of any 3 including the last 2 of the 5 fiscal years next preceding the date of acquisition by such insurance company of such bonds, debentures, or other evidences of indebtedness, the net earnings of the issuing, assuming or guaranteeing institution available for its fixed charges, as hereinafter defined, shall have been not less than 1 1/4 times the total of its fixed charges for such year, and provided, further, that no life insurance company shall invest in or loan upon the obligations of any one institution in the kinds permitted under this subsection an amount in excess of 25% of the total admitted assets of such insurer as of December 31st next preceding the date of such investment. As used in this subsection, the term net earnings available for fixed charges shall mean net income after deducting operating and maintenance expenses, taxes other than income taxes, depreciation and depletion, but excluding extraordinary non-recurring items of income or expense appearing in the regular financial statement of the issuing, assuming or guaranteeing institution. The term fixed charges shall include interest on funded and unfunded debt, amortization of debt discount, and rentals for leased properties. Preferred or guaranteed stocks of any solvent corporation or institution, created or existing under the laws of the Philippines, provided, however, that the issuing, assuming or guaranteeing entity or its predecessors has paid regular dividends upon its preferred or guaranteed stocks for a period of at least 3 years next preceding the date of investment in such preferred or guaranteed stock. Provided, further, that if the stocks are guaranteed, the amount of stocks so guaranteed is not excess of 50% of the amount of the preferred or common stocks, as the case may be, of the guaranteeing corporation, and provided, finally, that no life insurance company shall invest in or loan upon obligations of any one institution in the kinds permitted under this subsection an amount in excess of 10% of the total admitted assets of such insurer as of December 31st next preceding the date of such investment. Common stocks of any solvent corporation or institution, created or existing under the laws of the Philippines upon which regular dividends shall have been paid for the 3 years next preceding the purchase of such stock, provided, however, that no life insurance company shall invest in or loan upon the obligations of any one corporation or institution in the kinds permitted under this subsection an amount in excess of 10% of the total admitted assets of such insurer as of December 31st next preceding the date of such investment. G. Certificates, notes and other obligations issued by the trustees or receivers of any institution created or existing under the laws of the Philippines which, or the assets of which, are being administered under the direction of any court having jurisdiction, provided, however, that such certificates, notes or other obligations are adequately secured as to principal and interests. H. Equipment trust obligations or certificates, which are adequately secured or other adequately secured instruments evidencing an interest in equipment wholly or in part within the Philippines, provided, however, that there is a right to receive determined portions of rental, purchase or other fixed obligatory payments for the use or purchase of such equipment. The obligation of any corporation or institution, created or existing under the laws of the Philippines which is, on the date of acquisition, by the insurer, adequately secured and has qualities and characteristics wherein the speculative elements are not predominant. J. Such other securities as may be approved by the Commissioner. 3. Any domestic insurer which has outstanding insurance, annuity or reinsurance contracts in currencies other than the national currency of the Philippines may invest in or otherwise acquire or loan upon securities and investments in such currency which are substantially of the same kind, classes and investment grades as those eligible for investment under the foregoing subdivisions of this section, but the aggregate amount of such investment and of such cash in such currency which is at any time held by such insurer shall not exceed 1 1/2 times the amount of its reserves and other obligations under such contracts or the amount which such insurer is required by the law of any country or possession outside the Republic of the Philippines to be invested in such country or possession, whichever shall be greater. Section 201. An insurance company may 1. Invest in equities of other financial institutions, and 2. Engage in the buying and selling of short-term debt instruments, provided that any or all of such investments shall be with the prior approval of the Commissioner. Section 202. Any life insurance company may acquire or construct housing projects and, in connection with any such project, may acquire land or any interest therein by purchase, lease or otherwise, or use land acquired pursuant to any other provision of this code. Such company may thereafter own, maintain, manage, collect or receive income from, or sell and convey any land or interest therein so acquired and any improvements therein. The aggregate book value of the investments of any such company in all such projects shall not exceed at the time of such investments 25% of the total admitted assets of such company on the 31st day of December next preceding the acquire real property other than property to be used primarily for providing housing and property for accommodation of its own business as an investment for the production of income, or may acquire real property to be improved or developed for such investment purpose pursuant to a program, therefore, subject to the condition that the cost of each parcel of real property so acquired under the authority of this paragraph be, including the estimated cost to the company of the improvement or development thereof, when added to the book value of all other real property held by its pursuant to this paragraph B, shall not exceed 25% of its admitted assets as of the 31st day of December next preceding. Section 203. Every domestic insurance company shall, to the extent of an amount equal in value to 25% of the minimum paid-up capital required under Section 188, invest its funds only in securities satisfactory to the Commissioner, consisting of bonds or other evidences of debt of the government of the Philippines or its political subdivisions or instrumentalities, or of government-owned or controlled corporations and entities, including the Central Bank of the Philippines, provided that such investments shall at all times be maintained free from any lien or encumbrance, and provided, further, that such securities shall be deposited with and held by the Commissioner for the faithful performance by the depositing insurer of all its obligations under its insurance contracts. The provisions of Section 192 shall, so far as practicable, apply to the securities deposited under this section. except as otherwise provided in this code. No judgment creditor or other claimant shall have the right to levy upon any of the securities of the insurer held on deposit under this section or held on deposit pursuant to the requirement of the Commissioner, as amended by Presidential Decree Number 1455. Section 204. After satisfying the requirements contained in the preceding section, any domestic non-life insurance company shall invest, to an amount prescribed below, its funds in, or otherwise, acquire or loan upon, only the classes of investments described in Section 200, including securities issued by any registered enterprise, as this term is defined in Republic Act No. 5186, otherwise known as the Investment Incentive Act, and such other classes of investments as may be authorized by the Commissioner for purposes of this section, provided that no more than 20% of the net worth of such company as shown by its latest financial statement approved by the Commissioner shall be invested in the lot and building in which the insurance company conducts its business, and be the total investment of an insurance company in any registered enterprise shall not exceed 20% of the net worth of said insurance company as shown by its aforesaid financial statement, nor 20% of the paid-up capital of the registered enterprise excluding the intended investment, unless previously authorized by the Commissioner, and provided further that such investments free from any lien or encumbrance shall be at least equal in amount to the aggregate amount of its legal reserve, as provided in Section 213, and be its reserve fund held for reinsurance as provided for in the pertinent treaty provision in the case of reinsurance ceded to authorized insurers, as amended by Presidential Decree No. 1455. Section 205. After satisfying the requirements contained in Sections 191, 193, 203 and 204, any non-life insurance company may invest any portion of its funds representing earned surplus in any of the investments described in Sections 198, 200 and 201, or in any securities issued by a registered enterprise mentioned in the preceding sections, provided that no investment in stocks or bonds of any single entity shall in the aggregate exceed 20% of the net worth of the insurance company as shown in its latest financial statement approved by the Commissioner, or 20% of the paid-up capital of the issuing company, whichever is lesser unless otherwise approved by the Commissioner. Section 206. After satisfying the minimum capital investment required in Section 203, any life insurance company may invest its legal policy reserve, as provided in Section 211 or in Section 212, in any of the classes of securities or types of investments described in Sections 198, 200, 201 and 202, subject to the limitations therein contained, and in any securities issued by any registered enterprise mentioned in Section 204, free from any lien or encumbrance, in such amounts as may be approved by the Commissioner. Such company may likewise invest any portion of its earned surplus in the aforesaid securities or investments subject to the aforesaid limitations. Section 207. Any investment made in violation of the applicable provisions of this title shall be considered non-admitted assets. Section 208. 1. All bonds or other evidences of indebtedness having a fixed term and rate of interest and held by any life insurance company authorized to do business in this country, if amply secured and if not in default as to principal or interest, shall be valued as follows: if purchased at par, at the par value; if purchased above or below par, on the basis of the purchase price, adjusted so as to bring the value to par at maturity and so as to yield in the meantime the effective rate of interest at which the purchase was made, or in the discretion of the Commissioner, on the basis of the method of calculation commonly known as the pro rata method. In applying the foregoing rule, the purchase price shall in no case be taken at a higher figure than the actual market value at the time of acquisition. The Commissioner shall have the power to determine the eligibility of any such investments for valuation on the basis of amortization, and may by regulation prescribe or limit the classes of securities so eligible for amortization. All bonds or other evidences of indebtedness, which in the judgment of the Commissioner are not amply secured, shall not be eligible for amortization and shall be valued in accordance with paragraph 2. The Commissioner may, if he finds that the interest of policyholders so permit or require, by official regulation, permit or require any class or classes of insurers, other than life insurance companies, authorized to do business in this country, to value their bonds or other evidences of indebtedness, in accordance with the foregoing rule. 2. The investments of all insurers authorized to do business in this country, except securities subject to amortization and except as otherwise provided in this chapter, shall be valued in the discretion of the Commissioner at their market value or at their appraised value or at prices determined by him as representing their fair market value. If the Commissioner finds that in view of the character of investments of any insurer authorized to do business in this country, it would be prudent for such insurer to establish a special reserve for possible losses or fluctuations in the values of its investments, he may require such insurer to establish such reserve, reasonable in amount, and may require that such reserve be maintained and reported in any statement or report of the financial condition of such insurer. The Commissioner may, in connection with any examination or required financial statement of an authorized insurer, require such insurer to furnish incomplete financial statements and audited report of the financial condition of any corporation of which the securities are owned wholly or partly by such insurer, and may cause an examination to be made of any subsidiary or affiliate of such insurer. 3. The stock of an insurance company shall be valued at the lesser of its market value or its book value as shown by its last approved annual statement or the last report on examination, whichever is more recent. The book value of a share of common stock of an insurance company shall be ascertained by dividing the amount of its capital and surplus less the value of all of its preferred stock, if any, outstanding, by the number of shares of its common stock issued and outstanding. Notwithstanding the foregoing provisions, an insurer may, at its option, value its holdings of stock in a subsidiary insurance company in an amount not less than acquisition cost, if such acquisition cost is less than the value determined as hereinbefore provided. 4. Real estate required by foreclosure or by deed in lieu thereof, in the absence of a recent appraisal deemed by the Commissioner to be reliable, shall not be valued at an amount greater than the unpaid principal of the defaulted loan at the date of such foreclosure or deed, together with any taxes and expenses paid or incurred by such insurer at such time in connection with such acquisition, and the cost of additions or improvements thereafter paid by such insurer, and any amount or amounts thereafter paid by such insurer on any assessments levied for improvements in connection with a property. Shamraville's Virtual Law Library. 5. Purchase money mortgages received on dispositions of real property held pursuant to Section 198 shall be valued in an amount equivalent to 90% of the value of such real property. Purchase money mortgages received on disposition of real property otherwise held shall be valued in an amount not exceeding 90% of the value of such real property as determined by an appraisal made by an appraiser at or about the time of disposition of such real property. 6. The stock of a subsidiary of an insurer shall be valued on the basis of a greater by the value of only such subsidiary of the assets of such subsidiary as would constitute lawful investments for the insurer, if acquired or held directly by the insurer, or such other value, determined pursuant to standards and cumulative limitations, contained in a regulation to be promulgated by the Commissioner. 7. Notwithstanding any provision contained in this section or elsewhere in this chapter, if the Commissioner finds that the interests of policyholders so permit or require, he may permit or require any class or classes of insurers authorized to do business in this country to value their investments or any class or classes thereof as of any date heretofore or hereafter, in accordance with any applicable valuation or method. Section 209. It shall be the duty of the officers of the insurance company to report within the first 15 days of every month all such investments as may be made by them during the preceding month, and the Commissioner may, if such investments or any of them seem injudicious to him, require the sale or disposal of the same. The report shall also include a list of investments sold or disposed of by the company during the same period. Title 5. Reserves. Section 210. Every life insurance company doing business in the Philippines shall annually make a valuation of all policies, additions to rate, unpaid dividends, and all other obligations outstanding on the 31st day of December of the preceding year. All such valuations shall be made upon the net premiums basis, according to the standard adopted by the company, which standard shall be stated in its annual report. Such standard of valuation, whether of the net level premium, full preliminary term, any modified preliminary term, or select an ultimate reserve basis, shall be according to a standard table of mortality, with interest at not more than 6% on compound interest. When the preliminary term basis is used, the term insurance shall be limited to the first policy year. The results of such valuations shall be reported to the Commissioner on or before the 30th day of April of each year, accompanied by a sworn statement of the company's actuary certifying to the figures and stating upon what mortality table it is based, upon what rate of interest the valuation is made, and the methods used in arriving at the result obtained. Section 211. The aggregate net value so ascertained of the policies of such company shall be deemed its reserve liability, to provide for which it shall hold funds in secure investments equal to such net value above all its other liabilities, and it shall be the duty of the Commissioner, after having verified, to such an extent as he may deem necessary, the valuation of all policies in force, to satisfy himself that the company has such amount in safe legal securities after all other debts and claims against it have been provided for. The reserve liability for variable contracts defined in Section 232 shall be established in accordance with actuarial procedures that recognize the variable nature of the benefits provided and shall be approved by the Commissioner. Section 212. Every domestic life insurance company conducted on the mutual plan or a plan in which policyholders are by the terms of their policies entitled to share in the profits or surplus shall on all policies of life insurance heretofore or hereafter issued under the conditions of which the distribution of surplus is deferred to a fixed or specified time and contingent upon the policy being in force and the insured living at that time, annually ascertain the amount of the surplus to which all such policies as separate class are entitled, and shall annually apportion to such policies as a class the amount of the surplus so ascertained, and carry the amount of such apportioned surplus, plus the actual interest earnings and accretions to such fund, as a distinct and separate liability to such class of policies on, and for which the same was accumulated, and no company or any of its officers shall be permitted to use any part of such apportioned surplus fund, for any purpose whatsoever other than for the express purpose, for which the same was accumulated. Section 213. Every insurance company, other than life, shall maintain a reserve for unearned premiums on its policies in force, which shall be charged as a liability in any determination of its financial condition. Such reserve shall be equal to 40% of the gross premiums, less returns and cancellations, received on policies or risks having not more than a year to run, and pro rata on all gross premiums received on policies or risks having more than a year to run, provided that for marine cargo risks the reserve shall be equal to 40% of the premiums written in the policies upon yearly risks, and the full amount of the premiums written during the last 2 months of the calendar year upon all other marine risks not terminated. Section 214. In addition to its liabilities and reserves on contracts of insurance issued by it, every insurance company shall be charged with the estimated amount of all of its other liabilities, including taxes, expenses and other obligations due or accrued at the date of statement, and including any special reserves required by the Commissioner pursuant to the provisions of this code. Title 6. Limit of single risk. Section 215. No insurance company other than life, whether foreign or domestic, shall retain any risk on any one subject of insurance in an amount exceeding 20% of its net worth. For purposes of this section, the term subjective insurance shall include all properties or risks insured by the same insurer that customarily are considered by non-life company underwriters to be subject to loss or damage from the same occurrence of any hazard insured against. Reinsurance ceded as authorized under the succeeding title shall be deducted in determining the risk retained. As to surety risk, deduction shall also be made of the amount assumed by any other company authorized to transact surety business and the value of any security mortgaged, pledged, or held subject to the surety's control and for the surety's protection. Title 7. Reinsurance Transactions. Section 216. An insurance company, doing business in the Philippines, may accept reinsurances only if such risks, and retain risk-free and within such limits, as it is otherwise authorized to insure. Section 217. No insurance company, doing business in the Philippines, shall cede all or part of any risks, situated in the Philippines, by way of reinsurance directly, to any foreign insurer not authorized to do business in the Philippines unless such foreign insurer or, if the services of a non-resident broker are utilized, such non-resident broker is represented in the Philippines by a resident agent duly registered with a commissioner as required in this code. The resident agent of such unauthorized foreign insurer or non-resident broker shall immediately upon registration furnish the commissioner with the annual statement of such insurer or of such company or companies where such broker may place Philippine business as of the year preceding such registration and annually thereafter as soon as available. Section 218. All insurance companies, both life and non-life, authorized to do business in the Philippines, shall cede their excess risks to other companies similarly authorized to do business in the Philippines, in such amounts and under such arrangements as would be consistent with sound underwriting practices before they enter into reinsurance arrangements with unauthorized foreign insurers. Section 219. Any insurance company, doing business in the Philippines desiring to cede their excess risks to foreign insurance or reinsurance companies, not authorized to transact business in the Philippines, may do so under the following conditions. 1. Accept in facultative reinsurance in excess of loss covers. The full amount of the reserve fund required by law shall be set up in the books of and held by the ceding company for so long as the risk concerned is in force, provided that in case of facultative insurance, the ceding company shall show to the satisfaction of the commissioner that the Philippine market cannot provide the facilities sought abroad. 2. The reserve fund withheld shall be invested in bonds or other evidences of debt of the government of the Philippines or its political subdivisions or instrumentalities, or of government-owned or controlled corporations and entities, including the central bank, and or other securities acceptable under Section 200. Should any reinsurance agreement be for any reason cancelled or terminated, the ceding company concerned shall inform the commissioner in writing of such cancellation or termination within 30 days from the date of such cancellation or termination or from the date notice or information of such cancellation or termination is received by such company as the case may be. Section 220. A reinsurance company authorized to do business in the Philippines shall report to the commissioner on forms prescribed by him the particulars of reinsurance treaties as of the first day of January of the year following the approval of this code and shall thereafter similarly report to the commissioner particulars of any new treaties or changes in existing treaties. Section 221. No credit shall be allowed as an admitted asset or as a deduction from liability to any ceding insurer for reinsurance made, ceded, renewed, or otherwise becoming effective after January 1, 1975, unless the reinsurance shall be payable by the assuming insurer on the basis of the liability of the ceding insurer under the contract or contracts reinsured without diminution because of the insolvency of the ceding insurer, nor unless under the contract or contracts of reinsurance the liability for such reinsurance is assumed by the assuming insurer or insurers as of the same effective date, nor unless the reinsurance agreement provides that payments by the assuming insurer shall be made directly to the ceding insurer or to its liquidator, receiver, or statutory successor, except where the contract specifically provides another payee of such reinsurance in the event of the insolvency of the ceding insurer, and b. where the assuming insurer, with the consent of the direct insured or insureds, has assumed such policy obligations of the ceding insurer as direct obligations of the assuming insurer to the payees under such policies and in substitution for the obligations of the ceding insurer to such payees. Section 222. No life insurance company doing business in the Philippines shall reinsure its whole risk on any individual life or joint lives, or substantially all of its insurance in force, without having first obtained the written permission of the Commissioner. Title 8. Annual Statement. Section 223. Every insurance company doing business in the Philippines shall terminate its fiscal period on the 31st day of December every year, and shall annually, on or before the 30th day of April of each year, render to the Commissioner a statement, signed and sworn to by the chief officer of such company, showing, in such form and details as may be prescribed by the Commissioner, the exact condition of its affairs on the preceding 31st day of December. Any entry in the statement which is found to be false shall constitute a misdemeanor, and the officer signing such statement shall be subject to the penalty provided for under Section 419. Section 224. Every insurance company authorized under Title 10 of this chapter to issue, deliver, or use variable contracts shall annually file with the Commissioner separate annual statement of its separate variable accounts. Such statement shall be on a form prescribed or approved by the Commissioner, and shall include details as to all of the income, disbursements, assets, and liability items of and associated with the said separate variable accounts. Said statement shall be under oath of 2 officers of the company, and shall be filed simultaneously with the annual statement required by the preceding section. Section 225. Within 30 days after receipt of the annual statement approved by the Commissioner, every insurance company doing business in the Philippines shall publish in 2 newspapers of general circulation in the city of Manila, one published in English and one in Filipino, a full synopsis of its annual financial statement, showing fully the conditions of its business and setting forth its resources and liabilities. Title 9. Policy Forms. Section 226. No policy, certificate, or contract of insurance shall be issued or delivered within the Philippines unless in the form previously approved by the Commissioner, and no application form shall be used with, and no rider, clause, warranty, or endorsement shall be attached to, printed, or stamped upon such policy, certificate, or contract unless the form of such application, rider, clause, warranty, or endorsement has been approved by the Commissioner. Section 227. In the case of individual life or endowment insurance, the policy shall contain in substance the following conditions: a provision that the policyholder is entitled to a grace period either of 30 days or of 1 month within which the payment of any premium after the first may be made, subject at the option of the insurer to an interest charge not in excess of 6% per annum for the number of days of grace elapsing before the payment of the premium, during which period of grace the policy shall continue in full force, but in case the policy becomes a claim during the said period of grace before the overdue premium is paid, the amount of such premium with interest may be deducted from the amount payable under the policy in settlement. The provision that the policy shall be incontestable after it shall have been enforced during the lifetime of the insured for a period of 2 years, from its date of issue as shown in the policy, or date of approval of last reinstatement, except for non-payment of premium and except for violation of the conditions of the policy relating to military or naval service in time of war. See a provision that the policy shall constitute the entire contract between the parties, but if the company desires to make the application a part of the contract, it may do so, provided a copy of such application shall be endorsed upon or attached to the policy when issued, and in such case the policy shall contain a provision that the policy and the application therefore shall constitute the entire contract between the parties. The provision that if the age of the insured is considered in determining the premium and the benefits accruing under the policy, and the age of the insured has been misstated, the amount payable under the policy shall be such as the premium would have purchased at the correct age. If the policy is participating, a provision that the company shall periodically ascertain and apportion any divisible surplus accruing on the policy under conditions specified therein. A provision specifying the options to which the policyholder is entitled to in the event of default in a premium payment after 3 full annual premiums shall have been paid. Such option shall consist of 1. A cash surrender value payable upon surrender of the policy, which shall not be less than the reserve on the policy, the basis of which shall be indicated for the then current policy year, and any dividend additions thereto, reduced by a surrender charge, which shall not be more than 1/5 of the entire reserve, or 2 1/2% of the amount insured, and any dividend additions thereto. 2. One or more paid-up benefits on a plan or plans specified in the policy of such value as may be purchased by the cash surrender value. A provision that at any time after a cash surrender value is available under the policy, and while the policy is in force, the company will advance, on proper assignment or pledge of the policy and on sole security thereof, a sum equal to, or at the option of the owner of the policy, less than the cash surrender value on the policy, at a specified rate of interest, not more than the maximum allowed by law, to be determined by the company from time to time, but not more often than once a year, subject to the approval of the commissioner, and that the company will deduct from such loan value any existing indebtedness on the policy and any unpaid balance of the premium for the current policy year, and may collect interest in advance on the loan to the end of the current policy year, which provision may further provide that such loan may be deferred for not exceeding 6 months after the application therefore is made. A table showing in figures cash surrender values and paid-up options available under the policy each year upon default in premium payments, during at least 20 years of the policy, beginning with a year in which the values and options first become available, together with a provision that in the event of the failure of the policyholder to elect one of the said options within the time specified in the policy, one of said options shall automatically take effect, and no policyholder shall ever forfeit his right to same by reason of his failure to so elect. In case the proceeds of a policy are payable in installments or as an annuity, a table showing the minimum amounts of the installments or annuity payments. A provision that the policyholder shall be entitled to have the policy reinstated at any time within 3 years from the date of default of premium payment, unless the cash surrender value has been duly paid or the extension period has expired, upon production of evidence of insurability satisfactory to the company, and upon payment of all overdue premiums and any indebtedness to the company upon said policy, with interest rate not exceeding that which would have been applicable to said premiums and indebtedness in the policy years prior to reinstatement. Any of the foregoing provisions or portions thereof not applicable to single premium or term policies shall to that extent not be incorporated therein, and any such policy may be issued and delivered in the Philippines, which in the opinion of the Commissioner contains provisions on any one or more of the foregoing requirements more favorable to the policyholder than hereinbefore required. This section shall not apply to policies of group life or industrial life insurance. Section 228. No policy of group life insurance shall be issued and delivered in the Philippines unless it contains, in substance, the following provisions, or provisions, which in the opinion of the Commissioner are more favorable to the persons insured, or at least as favorable to the persons insured and more favorable to the policyholders. A provision that the policyholder is entitled to a grace period of either 30 days or of 1 month for the payment of any premium due after the first, during which grace period the death benefit coverage shall continue in force unless the policyholder shall have given the insurer written notice of discontinuance in advance of the date of discontinuance and in accordance with the terms of the policy. The policy may provide that the policyholder shall be liable for the payment of a pro rata premium for the time the policy is in force during such grace period. The provision that the validity of the policy shall not be contested except for non-payment of premiums after it has been in force for 2 years from its date of issue, and that no statement made by any insured under the policy relating to his insurability shall be used in contesting the validity of the insurance, with respect to which such statement was made after such insurance has been enforced prior to the contest, for a period of 2 years during such person's lifetime, nor unless contained in written instrument, signed by him. See a provision that a copy of the application, if any, of the policyholder shall be attached to the policy when issued, that all statements made by the policyholder or by persons insured shall be deemed representations and not warranties, and that no statement made by any insured shall be used in any contest, unless a copy of the instrument containing the statement is or has been furnished to such person or to his beneficiary. The provision setting forth the conditions, if any, under which the insurer reserves the right to require a person eligible for insurance to furnish evidence of individual insurability satisfactory to the insurer as a condition to part or all of his coverage. The provision specifying an equitable adjustment of premiums or of benefits or of both to be made in the event that the age of a person insured has been misstated. Such provision to contain a clear statement of the method of adjustment to be used. As a provision that any sum becoming due by reason of death of the person insured shall be payable to the beneficiary designated by the insured, subject to the provisions of the policy, in the event that there is no designated beneficiary as to all or any part of such sum living at the death of the insured, and subject to any right reserved by the insurer in the policy and set forth in the certificate to pay at its option a part of such sum not exceeding 500 pesos to any person appearing to the insurer to be equitably entitled thereto, by reason of having incurred funeral or other expenses incident to the last illness or death of the person insured. G. A provision that the insurer will issue to the policyholder for delivery to each person insured an individual certificate setting forth a statement as to the insurance protection to which he is entitled, to whom the insurance benefits are payable, and the rights set forth in paragraphs H, I, and J following. H. A provision that if the insurance, or any portion of it, on a person covered under the policy ceases, because of termination of employment or of membership in the class or classes eligible for coverage under the policy, such person shall be entitled to have issued to him by the insurer, without evidence of insurability, an individual policy of life insurance without disability or other supplementary benefits, provided application for the individual policy and payment of the first premium to the insurer shall be made within 30 days after such termination, and provided further that, 1. The individual policy shall be on any one of the forms, except term insurance, then customarily issued by the insurer at the agent for an amount not in excess of the coverage under the group policy, and 2. The premium on the individual policy shall be at the insurer's then customary rate applicable to the form and amount of the individual policy, to the class of risk to which such person then belongs, and to his age, attained on the effective date of the individual policy. I. A provision that if the group policy terminates or is amended so as to terminate the insurance of any class of insured persons, every person insured thereunder at the date of such termination whose insurance terminates and who has been so insured for 5 years prior to such termination date, shall be entitled to have issued to him by the insurer an individual policy of life insurance, subject to the same limitations as set forth in paragraph H, except that the group policy may provide that the amount of such individual policy shall not exceed the smaller of the amount of the person's life insurance protection, ceasing less the amount of any life insurance for what he is or becomes eligible under any group policy, issued or reinstated by the same or another reinsurer within 30 days after such termination, and be 2,000 pesos. J. A provision that if a person insured under the group policy dies during the 30-day period within which he would have been entitled to an individual policy issued to him in accordance with H and I above and before such individual policy shall have become effective, the amount of life insurance which he would have been entitled to have issued to him as an individual policy shall be payable as a claim under the group policy, whether or not application for the individual policy or the payment of the first premium has been made. In the case of a policy issued to a creditor to insure debtors of such creditor, a provision that the insurer will furnish to the policyholder for delivery to each debtor insured under the policy a form which will contain a statement that the life of the debtor is insured under the policy and that any death benefit paid thereunder by reason of his death shall be applied to reduce or extinguish indebtedness. The provisions of paragraphs F to J shall not apply to policies issued to a creditor to insure his debtors. If a group life policy is on a plan of insurance other than term, it shall contain a non-forfeiture provision or provisions which in the opinion of the Commissioner is or are equitable to the insured or the policyholder, provided that nothing herein contained shall be so construed as to require group life policies to contain the same non-forfeiture provisions as are required of individual life policies. Section 229. The term industrial life insurance, as used in this code, shall mean that form of life insurance under which the premiums are payable either monthly or oftener if the face amount of insurance provided in any policy is not more than 500 times that of the current statutory minimum daily wage in the city of Manila, and if the words industrial policy are printed upon the policy as part of the descriptive matter. An industrial life policy shall not lapse for non-payment of premium if such non-payment was due to the failure of the company to send its representative or agent to the insured at the residence of the insured or at some other place indicated by him for the purpose of collecting such premium, provided that the provisions of this paragraph shall not apply when the premium on the policy remains unpaid for a period of 3 months or 12 weeks after the grace period has expired. Section 230. In the case of industrial life insurance, the policy shall contain in substance the following provisions. A provision that the insured is entitled to a grace period of 4 weeks within which the payment of any premium after the first may be made, except that where premiums are payable monthly, the period of grace shall be either 1 month or 30 days, and that during the period of grace, the policy shall continue in full force. But if during such grace period the policy becomes a claim, then any overdue and unpaid premiums may be deducted from any amount payable under the policy in settlement. The provision that the policy shall be incontestable after it has been enforced during the lifetime of the insured for a specified period, not more than 2 years, from its date of issue, except for non-payment of premiums and except for violation of the conditions of the policy relating to naval or military service, or services auxiliary thereto, and except as to provisions relating to benefits in the event of disability as defined in the policy, and those granting additional insurance specifically against death by accident or by accidental means, or to additional insurance against loss of, or loss of use of, specific members of the body. See a provision that the policy shall constitute the entire contract between the parties, or if a copy of the application is endorsed upon and attached to the policy when issued, a provision that the policy and the application therefore shall constitute the entire contract between the parties, and in the latter case, a provision that all statements made by the insured shall, in the absence of fraud, be deemed representations and not warranties. The provision that if the age of the person insured or the age of any person considered in determining the premium or the benefits accruing under the policy has been misstated, any amount payable or benefit accruing under the policy shall be such as the premium paid would have purchased at the correct age. A provision that if the policy is a participating policy, the company shall periodically ascertain and apportion any divisible surplus accruing on the policy under the conditions specified therein. A provision that in the event of default in premium payments after 3 full years premiums have been paid, the policy shall be converted into a stipulated form of insurance, and that in the event of default in premium payments after 5 full years premiums have been paid, a specified cash surrender value shall be available in lieu of the stipulated form of insurance at the option of the policyholder. The net value of such stipulated form of insurance and the amount of such cash value shall not be less than the reserve on the policy and dividend additions thereto, if any, at the end of the last completed policy year for which premiums shall have been paid. The policy to specify the mortality table, rate of interest and method of valuation adopted to compute such reserve, exclusive of any reserve on disability benefits and accidental death benefits, less an amount not to exceed 2.5% of the maximum amount insured by the policy, and dividend additions thereto, if any, at the end of the last completed policy year for which premiums shall have been paid. The policy to specify the mortality table, rate of interest and method of valuation adopted to compute such reserve, exclusive of any reserve on disability benefits and accidental death benefits, less an amount not to exceed 2.5% of the maximum amount insured by the policy, and dividend additions thereto, if any, when the issue age is under 10 years, unless an amount not to exceed 2.5% of the current amount insured by the policy, and dividend additions thereto, if any, if the issue age is 10 years or older, unless any existing indebtedness to the company on or secured by the policy. A provision that the policy may be surrendered to the company at its home office within a period of not less than 60 days after the due date of a premium in default for the specified cash value, provided that the insurer may defer payment for not more than 6 months after the application therefore is made. A table that shows in figures the non-forfeiture benefits available under the policy every year upon default in payment of premiums during at least the first 20 years of the policy. Such table to begin with a year in which such values become available, and a provision that the company will furnish upon request an extension of such table beyond the year shown in the policy. A provision that specifies which one of the stipulated forms of insurance provided for under the provision of paragraph F of this section shall take effect in the event of the insured's failure within 60 days from the due date of the premium in default to notify the insurer in writing as to which one of such forms he has selected. A provision that the policy may be reinstated at any time within 2 years from the due date of the premium in default unless the cash surrender value has been paid or the period of extended term insurance expired upon production of evidence of insurability satisfactory to the company and payment of arrears of premiums with interest at a rate not exceeding 6% per annum payable annually. A provision that when a policy shall become a claim by death of the insured, settlement shall be made upon receipt of due proof of death, or not later than 2 months after receipt of such proof. A title on the face and on the back of the policy correctly describing its form, in a space on the front or the back of the policy for the name of the beneficiary, designated by the insured with a reservation of the insured's right to designate or change the beneficiary after the issuance of the policy. The policy may also provide that no designation or change of beneficiary shall be binding on the insurer until endorsed on the policy by the insurer, and that the insurer may refuse to endorse the name of any proposed beneficiary who does not appear to the insurer to have an insurable interest in the life of the insured. Such policy may also contain a provision that if the beneficiary designated in the policy does not surrender the policy with due proof of death within the period stated in the policy, which will not be less than 30 days after the death of the insured, or if the beneficiary is the estate of the insured, or is a minor, or dies before the insured, or is not legally competent to give valid release, then the insurer may make any payment thereunder to the executor or administrator of the insured, or to any of the insured's relatives by blood or legal adoption or connections, by marriage, or to any person appearing to the insurer to be equitably entitled thereto, by reason of having incurred expense for the maintenance, medical attention, or burial of the insured, and in a provision that when an industrial life insurance policy is issued providing for accidental or health benefits, or both, in addition to life insurance, the foregoing provisions shall apply only to the life insurance portion of the policy. Any of the foregoing provisions or portions thereof not applicable to non-participating or term policies shall to that extent not be incorporated therein. The foregoing provisions shall not apply to policies issued or granted pursuant to the non-forfeiture provisions prescribed in provisions of paragraphs F and I of this section, nor shall provisions of paragraphs F, G.H. and I hear if the required in term insurance of 20 years or less, but such term policies shall specify the mortality table, rate of interest, and method of computing reserves. Section 231. No policy of industrial life insurance shall be issued or delivered in the Philippines if it contains any of the following provisions: a provision that gives the insurer the right to declare the policy void because the insured has had any disease or ailment, whether specified or not, or because the insured has received institutional, hospital, medical or surgical treatment or attention, except a provision which gives the insurer the right to declare the policy void if the insured has, within 2 years prior to the issuance of the policy, received institutional, hospital, medical or surgical treatment or attention, and if the insured or the claimant under the policy fails to show that the condition occasioning such treatment or attention was not of a serious nature or was not material to the risk. The provision that gives the insurer the right to declare the policy void because the insured has been rejected for insurance, unless such right be conditioned upon a showing by the insurer that knowledge of such rejection would have led to a refusal by the insurer to make such contract. See a provision that allows the company to pay the proceeds of the policy at the death of the insured to any person other than the named beneficiary, except in accordance with a standard provision as specified under the provisions of paragraph M of the preceding section. The provision that limits the time within which any action at law or in equity may be commenced to less than 6 years after the cause of action shall accrue, and the provision that specifies any mode of settlement at maturity of less value than the amount insured by the policy plus dividend additions, if any, less any indebtedness to the company on the policy and less any premium that may by the terms of the policy be deducted, payments to be made in accordance with the terms of the policy. Nothing contained in this section nor in the provision of paragraph V of the preceding section relating to incontestability shall be construed as prohibiting the life insurance company from placing in its industrial life policies provisions limiting its liability with respect to 1. Death resulting from aviation other than as a fare-paying passenger on a regularly scheduled route between definitely established airports, and 2. Military or naval service, provided that if the liability of the company is limited as herein provided, such liability shall in no event be fixed at an amount less than the reserve on the policy, excluding the reserve for any additional benefits in the event of death by accident or accidental means, or for benefits in the event of any type of disability, less any indebtedness on or secured by such policy, nor shall any provision of this section apply to any provision in an industrial life insurance policy for additional benefits in the event of death by accident or accidental means. Title 10. Variable Contracts. Section 232. 1. No insurance company authorized to transact business in the Philippines shall issue, deliver, sell or use any variable contract in the Philippines unless and until such company shall have satisfied the Commissioner that its financial and general condition and its methods of operations, including the issue and sale of variable contracts, are not and will not be hazardous to the public or to its policy and contract owners. No foreign insurance company shall be authorized to issue, deliver or sell any variable contract in the Philippines unless it is likewise authorized to do so by the laws of its domicile. 2. The term variable contract shall mean any policy or contract on either a group or on an individual basis issued by an insurance company providing for benefits or other contractual payments or values thereunder to vary so as to reflect investment results of any segregated portfolio of investments or of a designated separate account in which amounts received in connection with such contracts shall have been placed and accounted for separately and apart from other investments and accounts. This contract may also provide benefits or values incidental to rate payable in fixed or variable amounts, or both. It shall not be deemed to be a security or securities as defined in the Securities Act as amended or in the Investment Company Act as amended, nor subject to regulation under said acts. 3. In determining the qualifications of a company requesting authority to issue, deliver, sell or use variable contracts, the Commissioner shall always consider the following: the history, financial and general condition of the company, provided that such company, if a foreign company, must have deposited with a commissioner for the benefit and security of its variable contract owners in the Philippines, securities satisfactory to the commissioner consisting of bonds of the government of the Philippines or its instrumentalities, with an actual market value of 2 million pesos, v. the character, responsibility and fitness of the officers and directors of the company, and c. the law and regulation under which the company is authorized in the state of domicile to issue such contracts. For if after notice and hearing the commissioner shall find that the company is qualified to issue, deliver, sell or use variable contracts in accordance with this code and the regulations and rules issued thereunder, the corresponding order authorization shall be issued. Any decision or order denying authority to issue, deliver, sell or use variable contracts shall clearly and distinctly state the reasons and grounds on which it is based. Section 233. Any insurance company issuing variable contracts pursuant to this code may in its discretion issue contracts providing a combination of fixed amount and variable amount of benefits and for option lump sum payment of benefits. Section 234. Every variable contract form delivered or issued for delivery in the Philippines, and every certified form evidencing variable benefits issued pursuant to any such contract on a group basis, and the application, writer and endorsement forms applicable thereto and used in connection therewith, shall be subject to the prior approval of the Commissioner. Section 235. Illustration of benefits payable under any variable contract shall not include or involve projections of past investment experience into the future and shall conform with the rules and regulations promulgated by the Commissioner. Section 236. Variable contracts may be issued on the industrial life basis, provided that the pertinent provisions of this code and of the rules and regulations of the Commissioner governing variable contracts are complied with in connection with such contracts. Section 237. Every life insurance company authorized under the provisions of this code to issue, deliver, sell or use variable contracts shall, in connection with same, establish one or more separate accounts to be known as separate variable accounts. All amounts received by the company in connection with any such contracts, which are required by the terms thereof, to be collected or applied to one or more designated separate variable accounts shall be placed in such designated account or accounts. The assets and liabilities of each such separate variable account shall at all times be clearly identifiable and distinguishable from the assets and liabilities in all other accounts of the company. Notwithstanding any provision of law to the contrary, the assets held in any such separate variable account shall not be chargeable with liabilities arising out of any other business the company conduct, but shall be held and applied exclusively for the benefit of the owners or beneficiaries of the variable contracts applicable thereto. In the event of the insolvency of the company, the assets of each such separate variable account shall be applied to the contractual claims of the owners or beneficiaries of the variable contracts applicable thereto. Except as otherwise specifically provided by the contract, no sale, exchange or other transfer of assets may be made by a company between any of its separate accounts or between any other investment account and one or more of its separate accounts, unless in the case of a transfer into a separate account, such transfer is made solely to establish the account or to support the operation of the contracts with respect to the separate account to which the transfer is made, or in case of a transfer from a separate account, such transfer would not cause the remaining assets of the account to become less than the reserves and other contract liabilities with respect to such separate account. Such transfer, whether into or from a separate account, shall be made by a transfer of cash, or by a transfer of securities having a valuation which could be readily determined in the marketplace, provided that such transfer of securities is approved by the Commissioner. The Commissioner may authorize other transfers among such accounts, if, in his opinion, such transfer would not be inequitable. All amounts and assets allocated to any such separate variable account shall be owned by the company, and with respect to same the company shall not be nor hold itself out to be a trustee. Section 238. Any insurance company which has established one or more separate variable accounts pursuant to the preceding section may invest and reinvest all or any part of the assets allocated to any such account in the securities and investments authorized by sections 198, 200, 201 and 202 for any of the funds of an insurance company in such amount or amounts as may be approved by the Commissioner. In addition thereto, such company may also invest in common stocks or other equities, which are listed on or admitted to trading in a securities exchange located in the Philippines, or which are publicly held and traded in the over-the-counter market, as defined by the Commissioner and as to which market quotations have been available, provided, however, that no such company shall invest in excess of 10% of the assets of any such separate variable accounts in any one corporation issuing such common stock. The assets and investments of such separate variable accounts shall not be taken into account in applying the quantitative investment limitations applicable to other investments of the company. In the purchase of common capital stock or other equities, the insurer shall designate to the broker or to the seller if the purchase is not made through a broker the specific variable account for which the investment is made. Section 239. Assets allocated to any separate variable account shall be valued at their market value on the date of any valuation, or if there is no readily available market, then in accordance with the terms of the variable contract applicable to such assets, or if there are no such contract terms, then in such manner as may be prescribed by the rules and regulations of the Commissioner. Section 240. The reserve liability for variable contracts shall be established in accordance with actuarial procedures that recognize the variable nature of the benefits provided and shall be approved by the Commissioner. Title 11. Claims Settlement. Section 241. No insurance company doing business in the Philippines shall refuse, without just cause, to pay or settle claims arising under coverages provided by its policies, nor shall any such company engage in unfair claim settlement practices. Any of the following acts by an insurance company, if committed without just cause and performed with such frequency as to indicate a general business practice, shall constitute unfair claim settlement practices: unknowingly misrepresenting to claimants pertinent facts or policy provisions relating to coverage at issue, b. failing to acknowledge with reasonable promptness pertinent communications with respect to claims arising under its policies, c. failing to adopt and implement reasonable standards for the prompt investigation of claims arising under its policies, d. not attempting in good faith to effectuate prompt, fair and equitable settlement of claims submitted in which liability has become reasonably clear, or e. compelling policyholders to institute suits to recover amounts due under its policies by offering without justifiable reason substantially less than the amounts ultimately recovered in suits brought by them. 2. Evidence as to numbers and types of valid and justifiable complaints to the Commissioner against an insurance company, and the Commissioner's complaint experience with other insurance companies writing similar lines of insurance shall be admissible in evidence in an administrative or judicial proceeding brought under this section. 3. If it is found, after notice and an opportunity to be heard, that an insurance company has violated this section, each instance of non-compliance with paragraph 1 may be treated as a separate violation of this section and shall be considered sufficient cause for the suspension or revocation of the company's certificate of authority. Section 242. The proceeds of a life insurance policy shall be paid immediately upon maturity of the policy, unless such proceeds are made payable in installments or as an annuity, in which case the installments or annuities shall be paid as they become due, provided, however, that in the case of a policy maturing by the death of the insured, the proceeds thereof shall be paid within 60 days after presentation of the claim and filing of the proof of the death of the insured. Refusal or failure to pay the claim within the time prescribed herein will entitle the beneficiary to collect interest on the proceeds of the policy for the duration of the delay at the rate of twice the ceiling prescribed by the monetary award, unless such failure or refusal to pay is based on the ground that the claim is fraudulent. The proceeds of the policy maturing by the death of the insured payable to the beneficiary shall include the discounted value of all premiums paid in advance of their due dates, but are not due and payable at maturity. Section 243. The amount of any loss or damage for which an insurer may be liable under any policy other than life insurance policy shall be paid within 30 days after proof loss is received by the insurer, and ascertainment of the loss or damage is made either by agreement between the insured and the insurer or by arbitration, but if such ascertainment is not had or made within 60 days after such receipt by the insurer of the proof of loss, then the loss or damage shall be paid within 90 days after such receipt. Refusal or failure to pay the loss or damage within the time prescribed herein will entitle the assured to collect interest on the proceeds of the policy for the duration of the delay at the rate of twice the ceiling prescribed by the monetary award, unless such failure or refusal to pay is based on the ground that the claim is fraudulent. Section 244. In case of any litigation for the enforcement of any policy or contract of insurance, it shall be the duty of the commissioner or the court, as the case may be, to make a finding as to whether the payment of the claim of the insured has been unreasonably denied or withheld, and in the affirmative case, the insurance company shall be adjudged to pay damages, which shall consist of attorney's fees and other expenses incurred by the insured person, by reason of such unreasonable denial or withholding of payment, plus interest of twice the ceiling prescribed by the monetary award of the amount of the claim due the insured from the date following the time prescribed in Section 242 or in Section 243, as the case may be, until the claim is fully satisfied, provided that the failure to pay any such claim within the time prescribed in said sections shall be considered prima facie evidence of unreasonable delay in payment. Title 12. Examination of companies. Section 245. The Commissioner shall require every insurance company doing business in the Philippines to keep its books, records, accounts and vouchers in such manner that he or his authorized representatives may readily verify its annual statements and ascertain whether the company is solvent and has complied with the provisions of this code or the circulars, instructions, rulings or decisions of the Commissioner. Section 246. The Commissioner shall at least once a year, and whenever he considers the public interest so demands, cause an examination to be made into the affairs, financial condition and method of business of every insurance company authorized to transact business in the Philippines and of any other person, firm or corporation managing the affairs and / or property of such insurance company. Such company, as well as such managing person, firm or corporation, shall submit to the examiner all such books, papers and securities as he may require, and such examiner shall also have the power to examine the officers of such company under oath touching its business and financial condition, and the authority to transact business in the Philippines of any such company shall be suspended by the Commissioner if such examination is refused, and such company shall not thereafter be allowed to transact further business in the Philippines until it has fully complied with the provisions of this section. Government-owned or controlled corporations or entities engaged in social private insurance shall similarly be subject to such examination by the Commissioner unless their respective charters otherwise provide. Title 13. Suspension or revocation of authority. Section 247. If the Commissioner is of the opinion upon examination of other evidence that any domestic or foreign insurance company is in an unsound condition, or that it has failed to comply with the provisions of law or regulations obligatory upon it, or that its condition or method of business is such as to render its proceedings hazardous to the public or to its policyholders, or that its paid-up capital stock, in the case of a domestic stock company, or its available cash assets, in the case of a domestic mutual company, or its security deposits, in the case of a foreign company, is impaired or deficient, or that the margin of solvency required of such company is deficient, the Commissioner is authorized to suspend or revoke all certificates of authority granted to such insurance company, its officers and agents, and no new business shall thereafter be done by such company or for such company by its agent in the Philippines, while such suspension, revocation, or disability continues or until its authority to do business is restored by the Commissioner. Before restoring such authority, the Commissioner shall require the company concerned to submit to him a business plan showing the company's estimated receipts and disbursements, as well as the basis therefor, for the next succeeding 3 years. The proceeds of the policy maturing by the death of the insured payable to the beneficiary shall include the discounted value of all premiums paid in advance of their due dates, but are not due and payable at maturity. Section 243. The amount of any loss or damage for which an insurer may be liable under any policy other than life insurance policy shall be paid within 30 days after proof loss is received by the insurer, and ascertainment of the loss or damage is made either by agreement between the insured and the insurer or by arbitration, but if such ascertainment is not had or made within 60 days after such receipt by the insurer of the proof of loss, then the loss or damage shall be paid within 90 days after such receipt. Refusal or failure to pay the bill as amended by Presidential Decree No. 1455. Title 14. Appointment of Conservator. Section 248. If at any time before or after the suspension or revocation of the certificate of authority of an insurance company as provided in the preceding title, the Commissioner finds that such company is in a state of continuing inability or unwillingness to maintain a condition of solvency or liquidity deemed adequate to protect the interest of policyholders and creditors, he may appoint a conservator to take charge of the assets, liabilities, and the management of such company, collect all monies and debts due said company, and exercise all powers necessary to preserve the assets of said company, reorganize the management thereof, and restore its liability. The said conservator shall have the power to overrule or revoke the actions of the previous management and board of directors of the said company, any provision of law or of the articles of incorporation or bylaws of the company, to the contrary notwithstanding, and such other powers as the Commissioner shall deem necessary. The conservator may be another insurance company, doing business in the Philippines, by officer or officers of such company, or any other competent and qualified person, firm or corporation. The remuneration of the conservator and other expenses attendant to the conservation shall be borne by the insurance company concerned. The conservator shall not be subject to any action, claim or demand by, or liability to, any person in respect of anything done or omitted to be done in good faith, in the exercise, or in connection with the exercise, of the powers conferred on the conservator. The conservator appointed shall report and be responsible to the Commissioner until such time as the Commissioner is satisfied that the insurance company can continue to operate on its own, and the conservatorship shall likewise be terminated should the Commissioner, on the basis of the report of the conservator or of his own findings, determine that the continuance in business of the insurance company would be hazardous to policyholders and creditors, in which case the provisions of Title 15 shall apply. Title 15. Proceedings upon insolvency. Section 249. Whenever, upon examination or other evidence, it shall be disclosed that the condition of any insurance company doing business in the Philippines is one of insolvency, or that its continuance in business would be hazardous to its policyholders and creditors, the Commissioner shall forthwith order the company to cease and desist from transacting business in the Philippines, and shall designate a receiver to immediately take charge of its assets and liabilities as expeditiously as possible, collect and gather all the assets and administer the same for the benefit of its policyholders and creditors, and exercise all the powers necessary for these purposes, including, but not limited to, bringing suits and foreclosing mortgages in the name of the insurance company. The Commissioner shall thereupon determine within 30 days whether the insurance company may be reorganized or otherwise placed in such condition so that it may be permitted to resume business with safety to its policyholders and creditors, and shall prescribe the conditions under which such resumption of business shall take place, as well as the time for fulfillment of such conditions. In such case, the expenses and fees in the collection and administration of the insurance company shall be determined by the Commissioner and shall be paid out of the assets of such company. If the Commissioner shall determine and confirm within the said period that the insurance company is solvent, as defined hereunder, or cannot resume business with safety to its policyholders and creditors, he shall, if the public interest requires, order its liquidation, indicate the manner of its liquidation and approve a liquidation plan and implement it immediately. The Commissioner shall designate a competent and qualified person as liquidator who shall take over the functions of the receiver previously designated and, with all convenient speed, reinsure all its outstanding policies, convert the assets of the insurance company to cash, or sell, assign or otherwise dispose of the same to the policyholders, creditors and other parties, for the purpose of settling the liabilities or paying the debts of such company, and he may, in the name of the company, institute such actions as may be necessary in the appropriate court to collect and recover accounts and assets of the insurance company, and to do such other acts as may be necessary to complete the liquidation as ordered by the Commissioner. The provisions of any law to the contrary notwithstanding, the actions of the Commissioner under this section shall be final and executory, and can be set aside, by the court upon petition, by the company, and only if there is convincing proof that the action is plainly arbitrary and made in bad faith. The Commissioner, through the Solicitor General, shall then file the corresponding answer, reciting the proceeding taken and praying the assistance of the court in the liquidation of the company. No restraining order or injunction shall be issued by the court enjoining the Commissioner from implementing his actions under this section, unless there is convincing proof that the action of the Commissioner is plainly arbitrary and made in bad faith, and the petitioner or plaintiff files, with a clerk or judge of the court in which the action is pending, a bond executed in favor of the Commissioner in an amount to be fixed by the court. The restraining order or injunction shall be refused or, if granted, shall be dissolved upon filing by the Commissioner, if he so desires, of a bond in an amount twice the amount of the bond of the petitioner or plaintiff, conditioned that it will pay the damages which the petition or plaintiff may suffer by the refusal or the dissolution of the injunction. The provisions of Rule 58 of the new Rules of Court, insofar as they are applicable, shall govern the issuance and dissolution of the restraining order or injunction contemplated in this section. All proceedings under this title shall be given preference in the courts. The Commissioner shall not be required to pay any fee to any public officer for filing, recording, or in any manner authenticating any paper or instrument relating to the proceedings. As used in this title, the term insolvency shall mean the inability of an insurance company to pay its lawful obligations as they fall due in the usual and ordinary course of business, as may be shown by its failure to maintain the margin of solvency required under Section 194 of this Code, as amended by Presidential Decree No. 1141 and further amended by Presidential Decree No. 1455. Section 250. In case of liquidation of an insurance company, after payment of the cost of the proceedings, including reasonable expenses and fees incurred in the liquidation to be allowed by the court, the Commissioner shall pay all allowed claims against such company under order of the court, in accordance with their legal priority. Section 251. The receiver or the liquidator, as the case may be, designated under the provisions of this title, shall not be subject to any action, claim or demand by, or liability to, any person in respect of anything done or omitted to be done in good faith, in the exercise, or in connection with the exercise, of the powers conferred on such receiver or liquidator. Title 16. Consolidation and Merger of Insurance Companies, Section 252. Upon prior notice to the Commissioner, two or more domestic insurance companies, acting through their respective boards of directors, may negotiate to merge into a single corporation, which shall be one of the constituent corporations, or consolidate into a single corporation, which shall be a new corporation to be formed by the consolidation. A common agreement of the proposed merger or consolidation shall be drawn up for submission to the stockholders or members of the constituent companies for adoption and approved in accordance with the provisions of the respective bylaws of the constituent companies and all existing laws that may be pertinent. Section 253. Such agreements shall include, aside from the proposed merger or consolidation, provisions relative to the manner of transfer of assets to an assumption of liabilities by the absorbing or acquiring company from the absorbed or dissolved company or companies, the proposed articles of merger or consolidation and bylaws of the surviving or acquiring company, the corporate name to be adopted, which should not be that of any other existing company transacting similar business or one so similar as to be calculated to mislead the public, the rights of the stockholders or members of the absorbed or dissolved companies, date of effectivity of the merger or consolidation, and such particulars as may be necessary to explain and make manifest the objects and purposes of the absorbing or acquiring company. Section 254. Upon execution of such agreement to merge or consolidate by and between or among the boards of directors of the constituent companies, notice thereof shall be mailed immediately to their policyholders and creditors. The company or companies to be absorbed or dissolved shall discharge all its accrued liabilities, otherwise, such liabilities shall, with the consent of its creditors, be transferred to and assumed by the absorbing or acquiring company, or such liabilities be reinsured by the latter. In the case of such policies as are subject to cancellation by the company or companies to be absorbed or dissolved, same may be cancelled pursuant to the terms thereof, in lieu of such transfer, assumption, or reinsurance. Section 255. Upon approval or adoption, in the meetings of the stockholders or members, called for the purpose, in each of the constituent companies of the agreement to merge or consolidate, all stockholders or members dissenting or objecting to merger or consolidation shall be paid the value of their shares by the company concerned in accordance with the bylaws thereof. Section 256. Upon the approval or adoption of the agreement to merge or consolidate by the stockholders or members of the constituent companies, the corresponding articles of merger or of consolidation shall be duly executed by the presidents and attested by the corporate secretaries and shall bear the corporate seals of the merging or consolidating companies setting forth 1. The plan of merger or the plan of consolidation, 2. As to each corporation, the number of shares outstanding, or in case of mutual corporations, the number of members, and 3. As to each corporation, the number of shares or members voted for and against such plan respectively. Thereafter, a certified copy of such articles of merger or consolidation, together with a certificate of approval or adoption by the stockholders or members of such articles of merger or consolidation, verified by affidavits of such officers and under the seal of the constituent companies, shall be submitted to the Commissioner, together with such other papers or documents, which the Commissioner may require for his consideration. Section 257. The articles of merger or of consolidation, signed and verified as hereinafter required, shall be filed with the Securities and Exchange Commission for its examination and approval. Section 258. Upon receipt from the Securities and Exchange Commission of the certificate of merger or of consolidation, the constituent companies shall surrender to the Commissioner their respective certificates of authority to transact insurance business. The absorbing or surviving company, in case of merger, or the newly formed company, in case of consolidation, shall immediately file with the Commissioner the corresponding application for issuance of a new certificate of authority to transact insurance business, together with a certified copy of the certificate of merger or of consolidation, and of the certificate of increase of stocks, if there is any, issued by the Securities and Exchange Commission. Section 259. Nothing in this title shall be construed to enlarge the powers of the absorbing or surviving company in case of merger or the newly formed company in case of consolidation, except those conferred by the certificate of merger or of consolidation and the articles of merger of consolidation or the amended articles of incorporation as registered with the Securities and Exchange Commission. Section 260. No director, officer, or stockholder of any such constituent companies shall receive any fee, commission, compensation, or other valuable consideration whatsoever, directly or indirectly, or in any manner aiding, promoting, or assisting in such merger or consolidation. Section 261. The merger and consolidation of companies under this code shall be subject to the provisions of the corporation law and, in those cases, specified in Republic Act No. 5455, as amended, be further subject to the provisions of said law. Title 17. Mutualization of Stock Life Insurance Companies Section 262. Any domestic stock life insurance company doing business in the Philippines may convert itself into an incorporated mutual life insurer. To that end, it may provide and carry out a plan for the acquisition of the outstanding shares of its capital stock for the benefit of its policyholders or any class or classes of its policyholders by complying with the requirements of this chapter. Section 263. Such plan shall include appropriate proceedings for amending the insurer's articles of incorporation to give effect to the acquisition by said insurer for the benefit of its policyholders or any class or classes thereof of the outstanding shares of its capital stock and the conversion of the insurer from a stock corporation into a non-stock corporation for the benefit of its members. The members of such non-stock corporation shall be the policyholders from time to time of the class or classes for whose benefit the stock of the insurer was acquired, and the policyholders of such other class or classes as may be specified in such corporations' articles of incorporation as they may be amended from time to time. Such plan shall be 1. Adopted by a vote of a majority of the directors, 2. Approved by the vote of the holders of at least a majority of the outstanding shares at a special meeting of shareholders, called for that purpose, or by the written consent of such shareholders, 3. Submitted to the Commissioner and approved by him in writing, 4. Approved by a majority vote of all the policyholders of the class or classes, for whose benefit the stock is to be acquired voting at an election by the policyholders, called for that purpose, subject to the provisions of Section 265. The terms policyholder or policyholders as used in this chapter shall be deemed to mean the person or persons insured under an individual policy of life insurance or of health and accident insurance or of any combination of life, health and accident insurance. They shall also include the person or persons to whom any annuity or pure endowment is presently or prospectively payable by the terms of an individual annuity or pure endowment contract, except where the policy or contract declares some other person to be the owner or holder thereof, in which case such other person shall be deemed policyholder. In any case where a policy or contract names 2 or more persons as joint insured, payees, owners or holders thereof, the person so named shall be deemed collectively to be one policyholder for the purpose of this chapter. In any case where a policy or contract shall have been assigned by assignment absolute on its face to an assignee other than the insurer, and such assignment shall have been filed at the principal office of the insurer at least 30 days prior to the date of any election or meeting referred to in this chapter, then such assignee shall be deemed at such election or meeting to be the policyholder. For the purpose of this chapter, the terms policyholder and policyholders include the employer to whom, or a president, secretary or other executive officer of any corporation or association to which a master group policy has been issued, but exclude the holders of certificates or policies issued under or in connection with a master group policy. Beneficiaries under unmatured contracts shall not as such be deemed to be policyholders, filed with a commissioner after having been approved as provided in this section. Section 264. The Commissioner shall examine the plan submitted to him under the provisions of subparagraph 3 of Section 263. He shall not approve such plan unless in his opinion the rights and interests of the insurer, its policyholders and shareholders, are protected, nor unless he is satisfied that the plan will be fair and equitable in its operation. Shamraville's Virtual Law Library Section 265. The election, prescribed by subparagraph 4 of Section 263, shall be called by the Board of Directors or the President, and every policyholder of a class or classes, for whose benefit the stock is to be acquired, whose insurance shall have been in force for at least 1 year prior to such election, shall have 1 vote, regardless of the number of policies or amount of insurance he holds, and regardless of whether such policies are policies of life insurance or policies of health and accident insurance or annuity contracts. Notice of such election shall be given to policyholders entitled to vote by mail from the principal office of such insurer at least 30 days prior to the date set for such election in a sealed envelope, postage prepaid, addressed to each such policyholder at his last known address. Voting shall be by one of the following methods: 1. At a meeting of such policyholders, held pursuant to such notice, by ballot in person or by proxy. 2. If not by the method described in the preceding subparagraph, then by mail pursuant to a procedure and on forms to be prescribed by such plan. Such election shall be conducted under the direction and supervision of 3 impartial and disinterested inspectors appointed by the insurer and approved by the commissioner. In case any person appointed as inspector fails to appear at such meeting or fails or refuses to act at such election, the vacancy, if occurring in advance of the convening of the meeting or in advance of the opening of the mail vote, may be filled in the manner prescribed for the appointment of inspectors and, if occurring at the meeting or during the canvass of the mail vote, may be filled by the person acting as chairman of said meeting or designated for that purpose in such plan. The decision, act, or certificate of a majority of the inspectors shall be effective in all respects as the decision, act, or certificate of all. The inspectors of election shall determine the number of policyholders, the voting power of each, the policyholders represented at the meeting or voting by mail, the existence of a quorum and the authenticity, validity, and effect of proxies. They shall receive votes, hear and determine all challenges and questions in any way arising in connection with the right to vote, count and tabulate all votes, determine the result, and do such other acts as are proper to conduct the vote with fairness to all policyholders. The inspectors of election shall, before commencing performance of their duties, subscribe to and file with the insurer and with the commissioner on oath that they, and each of them, will perform their duties impartially, in good faith, to the best of their ability and as expeditiously as impracticable. On the request of the insurer, the commissioner, a policyholder or his proxy, the inspectors shall make a report in writing of any challenge or question or matter determined by them and execute a certificate of any fact found by them. They shall also certify the result of such vote to the insurer and to the commissioner. Any report or certificate made by them shall be prima facie evidence of facts stated therein. All necessary expenses incurred in connection with such election shall be paid by the insurer. For the purpose of this section, a quorum shall consist of 5% of the policyholders of such insurer entitled to vote at such election. Section 266. In carrying out any such plan, the insurer may acquire any shares of its own stock by gift, bequest, or purchase. Any share so acquired shall, unless as a result of such acquisition all of the shares of the insurer shall have been acquired, be acquired in trust for the policyholders of the class or classes, for whose benefit the plan provides that the stock of the insurer shall be acquired as herein provided. Such shares shall be assigned and transferred on the books of such insurer and approved by the commissioner. Such trustees shall hold such stock in trust until all of the outstanding shares of capital stock of such insurer have been acquired, but for not longer than 30 years, with such extensions of not more than 5 years each as may be granted by the commissioner. Such extensions may be granted by the commissioner if the plan so provides, and if in his opinion the plan of acquisition of all of such stock can be completed within a reasonable period. Such trustees shall vote such stock at all corporate meetings at which stockholders have the right to vote. When all the outstanding shares of capital stock of such insurer have been acquired, all said shares shall be cancelled. The certificate of amendment of the insurer's articles of incorporation, giving effect thereto, shall be filed in accordance with the provisions of the corporation law, and the insurer shall become a non-stock corporation for the profit of its members, and such trust shall thereupon terminate. Thereafter such corporation shall be conducted for the mutual benefit, ratably, of its policyholders of the class or classes for whose benefit the stock was acquired, and shall have power to issue non-assessable policies on a reserve basis subject to all provisions of law applicable to incorporated life insurers issuing non-assessable policies on a reserve basis. Policies so issued may be upon the basis of full or partial participation therein, as agreed between the insurer and the insured. Upon the termination of any such voting trust, either in accordance with its terms or as a vote provided, such plan of mutualization shall terminate, unless theretofore completed. Upon such termination, unless the plan of mutualization provides for the disposition of the shares acquired by the insurer under such plan or for the disposition of the proceeds thereof, the shares held by such trustee shall be disposed of in accordance with an order of the court of competent jurisdiction in the judicial district in which is located the principal office of such insurer, made upon a verified petition of the commissioner. Section 267. Any such plan of mutualization may provide for the creation of a voting trust under a trust agreement for the holding and voting by 3 or more trustees of any portion or all of the shares of the insurer not required upon the adoption of such plan. The voting trustees shall be named in accordance with such plan, or, if no provision is made therein for the naming of such trustees, then by the insurer. The voting trust agreement and voting trustees shall be subject to the approval of the commissioner. Any or all of the trustees under such voting trust agreement may be the same person or persons as any or all of the trustees referred to in section 266. Such voting trust agreement shall provide that in the event of acquisition by the insurer of any of the shares of stock held thereunder in accordance with the provisions of the plan, such shares so acquired together with the voting rights thereof shall be transferred by the trustees named under the provisions of this section to the trustees named under the provisions of section 266. Any voting trust agreement created pursuant to the provisions of this section may be made irrevocable for not longer than 30 years and thereafter until the termination of the trust provided for in section 266. The trust, created pursuant to the provisions of this section, shall terminate in any event upon termination of the trust, provided for in section 266. Upon the termination of the trust, created pursuant to the provisions of this section, any shares held in such trust shall revert to the persons entitled thereto by law. Section 268. A repayment for the acquisition of any shares of the capital stock of such insurer, the purchase price of which is not fixed by such plan, shall be subject to the prior approval of the commissioner. Neither such plan nor any such payment may be approved by the commissioner unless he finds that the rights and interests of the insurer, its policyholders, and shareholders are protected. Section 269. The trustees, referred to in section 266, shall file with such insurer and with a commissioner a verified acceptance of their appointments and verified declarations that they will faithfully discharge their duties as such trustees. All dividends and other sums received by said trustees on the shares held by them after paying the necessary expenses of executing their trust shall be immediately repaid to such insurer for the benefit of all who are or may become policyholders of such insurance of the class or classes for whose benefit the stock of such insurer was acquired and entitled to participate in the profits thereof, and shall be added to and become part of the assets of such insurer. Section 269A. If, at any time within the period provided in the plan for the acquisition of the outstanding shares of stock of the insurer, 90% thereof has already been acquired and transferred to the trustees under the plan, the insurer, by a vote of a majority of the directors, may determine to make an offer with the permission of the commissioner and subject to such requirement as he may specify, to acquire by purchase all of the shares not theretofore acquired under the plan at a specified price, which the insurer considers to be their fair value as of the date of making such offer. If the offer to acquire is permitted by the Commissioner, the insurer shall make a written offer by registered mail to each shareholder whose shares have not theretofore been acquired under the plan or otherwise offering to acquire all his shares at such price, if accepted in writing within 30 days after the mailing of such offer. Any shareholder accepting such offer within the time therefore shall, within 60 days after his acceptance, transfer to the insurer the certificates representing such shares and, upon doing so, shall be paid by the insurer the amount of such offer for his shares. Any share so acquired shall be assigned and transferred to the trustees under the plan and held by them as shares acquired pursuant to the plan. Each shareholder who does not accept such offer to acquire his shares within the time stated in such offer for acceptance thereof till within 15 days after the expiration of such offer apply to the Secretary of Finance for determination of the fair value of his shares as of the date of making such offer. The Secretary of Finance may himself, after due notice and hearing, determine upon the evidence received the fair value of the shares as of the date of making such offer, or appoint 3 impartial and disinterested persons to appraise the fair value of such shares, with such direction as he shall deem proper and necessary to expedite the proceedings. Upon completion of the appraisal proceedings, the appraisers shall file with the Secretary of Finance their report in writing stating the fair value of such shares as of the date of the making of such offer and setting forth their findings in support of such statement. The appraisers shall furnish each party to the proceedings a copy of their appraisal report, and within 10 days after receipt thereof any such party may signify his objection, if any, to the report or move for the approval thereof. Upon the expiration of the period of 10 days, referred to above, the report shall be set for hearing, after which the Secretary of Finance shall issue an order adopting, modifying or rejecting the report in whole or in part, or he may receive further evidence or may recommit it with instructions. Whenever the Secretary of Finance shall determine in any manner, as aforesaid, the fair value of such shares, he may also determine the terms of payment thereof by the insurer. The expenses incidental to the proceedings, including charges of the appraisers, if any, shall be paid equally by the insurer and the shareholder. Chanreville's Virtual Law Library. The findings of the Secretary of Finance on all questions of fact raised at the hearing of the application for determination of the fair value of such shares shall be conclusive upon all parties to the proceedings. The order of the Secretary of Finance determining the fair value of the shares and the terms of payment thereof shall have the force and effect of a judgment which shall be appealable on any question of law. Such order shall become final and executory 15 days after receipt thereof by the parties to the proceedings. Upon any such order becoming final and from which no appeal is pending, or when the time to appeal the referendum has expired, each shareholder party to the proceedings shall transfer his shares to the insurer and surrender to the said insurer the certificates representing such shares, and the insurer shall make payment therefore as provided in such order. Any share so acquired by the insurer shall be assigned and transferred to the trustees and held by them as shares acquired pursuant to the plan. Any shareholder who does not apply to the Secretary of Finance in the manner and within the time hereinbefore prescribed shall be deemed to have accepted the offer referred to above, effective, however, upon the expiration of the time hereinabove prescribed for making such application, and such shareholder's time for accepting such offer shall, for that purpose only, be deemed to have been extended accordingly. Any offer to acquire shares made pursuant to this section shall, except as otherwise provided herein, be irrevocable until all proceedings upon such offer have been completed or all shares have otherwise been earlier acquired by the insurer. Any shareholder who has expressly or impliedly accepted the plan or the offer to acquire his shares not theretofore acquired under the plan, and any shareholder who has rejected such plan or such offer and has applied, as aforesaid, to the Secretary of Finance for a determination of the fair value of the shares subsequent to which an agreement has been reached or a final order issued fixing such fair value, but who fails to surrender his certificates for cancellation upon payment of the amount to which he is entitled may be compelled to do so by an order of the Secretary of Finance for that purpose, and such order may provide that upon failure of such shareholder to surrender such certificates for cancellation, such order shall stand in lieu of such surrender and cancellation, as amended by Presidential Decree No. 1280, Section 270. Such insurer, after mutualization, shall be a continuation of the original insurer, and such mutualization shall not affect such insurer's certificate of authority nor existing suits, rights, or contracts except as provided in said plan for the acquisition of the outstanding shares of the capital stock of such insurer, approved as provided in this chapter. Such insurer, after mutualization, shall exercise all the rights and powers and shall perform all the duties conferred or imposed by law upon insurers, writing the classes of insurance written by it, and to protect rights and contracts existing prior to mutualization, subject to the effect of said plan. The Board of Directors of such insurer, prior to mutualization, may adopt amendments to its bylaws to take effect upon mutualization. Section 271. An annual meeting of members shall be held at 10 o'clock in the morning of the fourth Tuesday of March of each year at the principal office of the insurer, unless a different time or place be provided in the bylaws. 2 special meetings of the members, for any purpose or purposes whatsoever, may be called at any time by the President, or by the Board of Directors, or by one or more members holding not less than 1/5 of the voting power of such insurer, or by such other officers or persons as the bylaws authorize. Free notice of all meetings of members, whether annual or special, shall be given in writing to the members entitled to vote by the Secretary, or an Assistant Secretary, or other person charged with that duty, or if there be no such officer, or in case of his neglect or refusal, by any director or member. At the option of the insurer, such notice may be imprinted on premium notices of receipts or on both. A notice may be given by such insurer to any member either personally or by mail or other means of written communication, charges prepaid, addressed to such member at his address appearing on the books of the insurer or given by him to the insurer for the purpose of notice. If a member gives no address, notice shall be deemed to have been given him if sent by mail or other means of written communication addressed to the place where the principal office of the insurer is situated, or if published at least once in some newspaper of general circulation in the place in which said office is located. Notice of any meeting of members shall be sent to each member entitled to read not less than 7 days before such meeting, unless the bylaws provide otherwise. Notice of any meeting of members shall specify the place, the day and the hour of the meeting and the general nature of the business to be transacted. Notice of an annual meeting to be held at the time and place specified in subparagraph 1 of this section shall be sufficiently given if published at least once in each of 4 successive weeks in a newspaper of general circulation in the place in which the principal office of such insurer is located, and if so published no other notice of such meeting shall be required. For the presence, in person or by proxy, of 5% of the members entitled to vote at any meeting shall constitute a quorum for the transaction of business, unless otherwise provided by the bylaws. 5 Each such member shall have 1 vote at any meeting of members regardless of the number of policies or the amount of insurance that such member holds, and regardless of whether such policies are policies of life insurance or of health and accident insurance, or both. Any member entitled to vote shall have the right to do so either in person or by an agent or agents, authorized by a written proxy, executed by such person or his duly authorized agent and filed with the Secretary of such insurer. 6. The directors of the insurer in office at the time the insurer is mutualized as provided in this chapter shall continue in office until the first annual meeting of members. At the first annual meeting of members and at each annual meeting thereafter, directors shall be elected by the members for the term or terms authorized by this chapter. 7. The Articles of Incorporation or the bylaws may provide that the directors may be divided into 2 or more classes whose terms of office shall expire at different times, but no terms shall continue longer than 6 years. In the absence of such provisions, each director, except members of the board of directors at the time the insurer is mutualized, shall be elected for a term of 1 year. All directors shall hold office for a term for which they are elected and until their successors are elected and qualified. A director may, but need not be a member or policyholder of the insurer of which he is acting as director. Vacancies in the board of directors may be filled by a majority of the remaining directors, though less than a quorum, and each director so elected shall hold office until the next annual meeting. 8. All insurers mutualized under the provisions of this chapter shall be subject to all other applicable provisions of this code and of the corporation law. Section 272. The provisions of Commonwealth Act No. 83, otherwise known as the Securities Act, as amended, shall not apply to any of the following: shares of the capital stock of such insurer, acquired as provided in Section 266 and assigned and transferred to the trustees as is provided in said section, and the assignment and transfer of said shares as so provided, via any certificate or other instrument issued to a policyholder of such mutualized insurer conferring or evidencing membership in such mutualized insurer or conferring or evidencing such member's right to participate in the profits or share in the assets of such mutualized insurer by the virtue of his membership therein, and the issuance of such certificate or other instrument. See the plan for the acquisition of the outstanding shares of the capital stock of such insurer, authorized by the provisions of this chapter. The submission of said plan to the Commissioner and to the policyholders of such insurer as provided in this chapter, and the approval and carrying out of said plan or any part thereof, in accordance with the provisions of this chapter. Title 18. Withdrawal of Foreign Insurance Companies. Section 273. A foreign insurance company, doing business in the Philippines, upon payment of a fee hereinafter prescribed and surrender to the Commissioner of its certificate of authority, may apply to withdraw from the Philippines. Such application shall be duly executed in writing, accompanied by evidence of due authority for such execution, properly acknowledged. Section 274. The Commissioner shall publish the application for withdrawal daily for a period of 1 week in 2 newspapers of general circulation in the city of Manila, one in English and the other in Filipino. The expenses of such publication shall be paid by the insurance company filing such application. Section 275. Every foreign insurance company desiring to withdraw from the Philippines shall, prior to such withdrawal, discharge its liabilities to policyholders and creditors in this country. In case of its policies insuring residents of the Philippines, it shall cause the primary liabilities under such policies to be reinsured and assumed by another insurance company authorized to transact business in the Philippines. In the case of such policies as are subject to cancellation by the withdrawing company, it may cancel such policies pursuant to the terms thereof, in lieu of such reinsurance and assumption of liabilities. Section 276. The Commissioner shall make an examination of the books and records of the withdrawing company, and if, upon such examination, the Commissioner finds that the insurer has no outstanding liabilities to residents of the Philippines, it shall cancel the withdrawing company's certificate of authority if unexpired, and shall permit the insurer to withdraw. The cost and expenses of all such examination shall be paid as prescribed in Section 417. Section 277. Upon the failure of such withdrawing insurance company or its agents in the Philippines to pay the expenses of such publication within 30 days after the presentation of the bill, therefore, the Commissioner shall collect such fee from the deposit, furnished in accordance with the provisions of Section 191. Section 278. A foreign life insurance company that withdraws from the Philippines shall be considered a servicing insurance company if its business transactions are confined to accepting periodic premium payments from or granting policy loans and paying cash surrender values of outstanding policies to or reviving lapsed policies of Philippine policyholders and such other related services. Section 279. No company shall act as a servicing insurance company until after it shall have obtained a special certification of authority to act as such from the Commissioner upon application, therefore, and payment by the company of the fees hereinafter prescribed. Such certificate shall expire on the last day of June of each year and shall be renewed annually while the company continues to service its policyholders and to comply with all the applicable provisions of law and regulations. Title 19. Professional Reinsurers. Section 280. Except as otherwise provided in this code, no person, partnership, association, or corporation shall transact any business in the Philippines as a professional reinsurer until it shall have obtained a certificate of authority for that purpose from the Commissioner upon the application, therefore, and payment by such person, partnership, association, or corporation of the fees hereinafter prescribed. As used in this code, the term professional reinsurer shall mean any person, partnership, association, or corporation that transacts solely and exclusively reinsurance business in the Philippines. The Commissioner may refuse to issue a certificate of authority to any such person, partnership, association, or corporation if, in his judgment, such refusal will best promote public interest. No such certificate of authority shall be granted to any such person, partnership, association, or corporation unless and until the Commissioner shall have satisfied himself by such examination as he may make and such evidence as he may require that such person, partnership, association, or corporation is qualified by the laws of the Philippines to transact business therein as a professional reinsurer. Before issuing such certificate of authority of the Commissioner must be satisfied that the name of the applicant is not that of any other known company transacting insurance or reinsurance business in the Philippines, or a name so similar as to be calculated to mislead the public. Such certificate of authority shall expire on the last day of June of each year and shall be renewed annually if such person, partnership, association, or corporation is continuing to comply with provisions of this code or the circulars, instructions, rulings, or decisions of the Commissioner and such other pertinent law, rules, and regulations. Every such person, partnership, association, or corporation receiving such certificate of authority shall be subject to the provisions of this code and other related laws, and to the jurisdiction and supervision of the Commissioner. Section 281. Any person, partnership, association, or corporation authorized to transact solely reinsurance business must have a paid-up capital stock of at least 10 million pesos, 25% of which must be invested in securities satisfactory to the Commissioner, consisting of bonds or other evidences of debt of the government of the Philippines or its political subdivisions or instrumentalities, or of government-owned or controlled corporations and entities, including the Central Bank of the Philippines, and deposited with the Commissioner, and the remaining 75% in such other securities as may be allowed and permitted by the Commissioner, which securities shall at all times be maintained free from any lien or encumbrance, provided that reinsurers already doing business as such in the Philippines shall comply with the requirement of this section by increasing their respective capital as herein provided not later than December 31, 1980, provided further that the provisions of this chapter applicable to insurance companies shall so far as practicable be likewise applicable to professional reinsurers, as amended by Presidential Decree No. 1455. Title 20. Holding Companies. Section 282. As used in this title, the following terms shall have the respective meanings hereinafter set forth, unless the context shall otherwise require. A person means an individual, partnership, firm, association, corporation, trust, any similar entity or any combination of the foregoing acting in concert. B. Control, including the terms controlling, controlled by, and under common control with, means the possession directly or indirectly of the power to direct or cause the direction of the management and policies of a person, whether through the ownership of voting securities, by a contract other than a commercial contract, for goods or non-management services or otherwise. Subject to Section 208(4), control shall be presumed to exist if any person directly or indirectly owns, controls or holds, with the power to vote 40% or more of the voting securities of any other person, provided that no person shall be deemed to control another person solely by reason of his being an officer or director of such other person. C. Holding company means any person who directly or indirectly controls any authorized insurer. D. Controlled insurer means an authorized insurer, controlled directly or indirectly by a holding company. E. Controlled person means any person other than a controlled insurer who is controlled directly or indirectly by a holding company. F. Holding company system means a holding company together with its controlled insurers and controlled persons. Section 283. Notwithstanding paragraph V of Section 282, the Commissioner may determine after notice an opportunity to be heard that a person exercises directly or indirectly either alone or pursuant to an agreement with one or more other persons such a controlling influence over the management or policies of an authorized insurer as to make it necessary or appropriate in the public interest or for the protection of policyholders or stockholders of the insurer, that the person be deemed to control the insurer. Section 284. The Commissioner may determine upon application that any person, either alone or pursuant to agreement with one or more other persons, does not or will not upon the taking of some proposed action control another person. The filing of an application hereunder in good faith by any person shall relieve the applicant from any obligation or liability imposed by this title with respect to the subject of the application, except as contained in Section 294, until the Commissioner has acted upon the application. Within 30 days or such further period as he may prescribe, the Commissioner may prospectively revoke or modify his determination after notice an opportunity to be heard whenever in his judgment revocation or modification is consistent with his title. Section 285. Notwithstanding any other provisions of this title, the following shall not be deemed holding companies, authorized insurers or reinsurers or their subsidiaries, be the government of the Philippines, or any political subdivision, agency or instrumentality thereof, or any corporation which is wholly owned directly or indirectly by one or more of the foregoing. The Commissioner may conditionally or unconditionally exempt any specified person or class of persons from any of the obligations or liabilities imposed under this title if and to the extent he finds the exemption necessary to appropriate in the public interest or not adverse to the interests of policyholders or stockholders and consistent with the purposes of this title. Section 286. 1. Every person who on the date this code takes effect is a controlled insurer, and every person who thereafter becomes a controlled insurer shall, within 60 days thereafter, or within 30 days after becoming a controlled insurer, whichever is later, register with the Commissioner. Such registration shall be amended within 30 days following any change in the identity of its holding company. The Commissioner may grant one or more reasonable extensions of the time to register. 2. Every registrant shall furnish the Commissioner with the following information concerning its holding company: a copy of its charter or articles of incorporation and its bylaws, the identities of its principal shareholders, officers, directors and controlled persons, and C. Information as to its capital structure and financial condition, and a description of its principal business activities. Section 287. Every controlled insurer shall file with the Commissioner such reports or material as he may direct, for the purpose of disclosing information concerning the operations of persons within the holding company system, which may materially affect the operations, management or financial condition of the insurer. Section 288. Every holding company and every controlled person within a holding company system shall be subject to examination by order of the Commissioner if he has cause to believe that the operations of such persons may materially affect the operations, management or financial condition of any controlled insurer with a system and that he is unable to obtain relevant information from such controlled insurer. The grounds relied upon by the Commissioner for such examination shall be stated in his order, which order shall be subject to judicial review only at the instance of the person sought to be examined. Such examination shall be confined to matters specified in the order. The cost of such examination shall be assessed against the person examined, and no portion thereof shall thereafter be reimbursed to it directly or indirectly by the controlled insurer. Section 289. The Commissioner shall keep the contents of each report made pursuant to this title and any information obtained by him in connection therewith confidential, and shall not make the same public without the prior written consent of the controlled insurer to which it pertains, unless the Commissioner, after notice and an opportunity to be heard, shall determine that the interests of policyholders, stockholders, or the public will be served by the publication thereof. In any action or proceeding by the Commissioner against the person examined or any other person within the same holding company system, a report of such examination, published by him, shall be admissible as evidence of the facts stated therein. Section 290. Transactions within a holding company system to which a controlled insurer is a party shall be subject to the following. The terms shall be fair and equitable. The charges or fees for services performed shall be reasonable. The expenses incurred and payments received shall be allocated to the insurer on an equitable basis, in conformity with customary insurance accounting practices consistently applied. The books, accounts, and records of each party to all such transactions shall be maintained as to clearly and accurately disclose the nature and details of the transactions, including such accounting information as is necessary to support the reasonableness of the charges or fees to the respective parties. Section 291. The prior written approval of the Commissioner shall be required for the following transactions between a controlled insurer and any person in its holding company system: sales, purchases, exchanges, loans or extensions of credit, or investments involving 5% or more of the insurer's admitted assets as of the 31st day of December next preceding. Section 292. The following transactions between a controlled insurer and any person in its holding company system may not be entered into unless the insurer has notified the Commissioner in writing of its intention to enter into any such transaction at least 30 days prior thereto, or such shorter period as he may permit, and he has not disapproved it within such period. A sales, purchases, exchanges, loans or extensions of credit, or investments involving more than 0.5% but less than 5% of the insurer's admitted assets as of the 31st day of December next preceding. The reinsurance treaties or agreements, C. rendering of services on a regular or systematic basis, or D. any material transaction specified by regulation which the Commissioner determines may adversely affect the interest of the insurer's policyholders or stockholders or of the public. Nothing herein contained shall be deemed to authorize or permit any transaction which, in the case of a non-controlled insurer, would be otherwise contrary to law. Section 293. The Commissioner, in reviewing transactions pursuant to Sections 291 and 292, shall consider whether the transactions comply with the standard set forth in Section 290 and whether they may adversely affect the interests of policyholders. This section shall not apply to transactions subject to other sections of this code which impose notice or approval requirements greater than those prescribed by this title. Section 294. 1. No person other than an authorized insurer shall acquire control of any domestic insurer, whether by purchase of its securities or otherwise, except after 20 days written notice to its insurer or such shorter period as the Commissioner may permit of its intention to acquire control, and B. with a prior written approval of the Commissioner. 2. The Commissioner shall disapprove the acquisition of control of a domestic insurer if he determines, after notice and an opportunity to be heard, that such action is reasonably necessary to protect the interest of the people of this country. The following shall be the only factors to be considered by him in reaching the foregoing determination of the financial condition of the acquiring person or of the insurer, v. the trustworthiness of the acquiring person or any of its officers or directors, c. a plan for the proper and effective conduct of the insurer's operations, d. the source of the funds or assets for the acquisition, e. the fairness of any exchange of stock, assets, cash or other consideration for the stock or assets to be received, f. whether the effect of the acquisition may be substantially to lessen competition in any line of commerce in insurance or to tend to create a monopoly therein, and g. whether the acquisition is likely to be hazardous or prejudicial to the insurer's policyholders or stockholders. 3. The following conditions affecting any controlled insurer, regardless of when such control has been acquired, are violations of this title of a controlling person or any of its officers or directors have demonstrated untrustworthiness, and b. the effect of retention of control may be substantially to lessen competition in any line of commerce in insurance in this country or to tend to create a monopoly therein. If, after notice and an opportunity to be heard, the Commissioner determines that any of the foregoing violations exists, he shall reduce his findings to writing and shall issue an order, based therein and cause the same to be served upon the insurer and upon all persons affected thereby, directing any person found to be in violation thereof to take appropriate action to cure such violation. Upon the failure of any such person to comply with such order, Section 298 shall become applicable. 4. The Commissioner may require the submission of such information as he deems necessary to determine whether any acquisition or retention of control complies with this title, and may require, as a condition of approval of such acquisition or retention of control, that all or any portion of such information be disclosed to the insurer's stockholders. 5. Unless subject to registration under Section 286, or unless acquisition of its control is subject to paragraphs 1 and 2 herewith, every authorized insurer shall, on or before the first day of July, 1975, or within 30 days after any event requiring notice hereunder, whichever is later, notify the Commissioner in writing of the identity of any person whom the insurer then knows or has reason to believe controls or has taken any action other than preliminary negotiations or discussion to acquire control of the insurer. Section 295. 1. Notwithstanding the control of an authorized insurer by any person, the officers and directors of the insurer shall not thereby be relieved of any obligation or liability to which they would otherwise be subject by law, and the insurer shall be managed so as to assure its separate operating identity consistent with this title. 2. Nothing herein shall preclude an authorized insurer from having or sharing a common management or cooperative or joint use of personnel, property or services with one or more other persons under arrangements meeting the standards of Section 290. Section 296. To the extent that any information or material is set forth in forms or other matter on file with any government agency or in a registration form filed with a commissioner by another person within the same holding company system, the controlled insurer may comply with the registration or reporting requirements of this title by referring in its registration form or report to such other filed matter and attaching a copy thereof certified by the insurer as a true and complete copy to such registration form or report, or, if such other filed matter is on file with a commissioner, incorporating such matter by reference. Section 297. No holding company or controlled person shall directly or indirectly or through another person do or cause to be done for or in behalf of a controlled insurer any act intended to affect the insurance operations of the insurer which, if done by the insurer, would violate any provision of this code. Section 298. In addition to any other penalty provided by law, the Commissioner may, upon the willful failure of any person within a holding company system to comply with this title or any regulation or order promulgated hereunder, proceed under Title 14 or Title 15 Chapter III of this code with respect to insurer within the holding company system or be revoked or refuse to renew the authority to do business in this country of an insurer within the holding company system or refuse to issue such authority to any other insurer in the system or see direct that, in addition to any other penalty provided by law, such person forfeit to the people of this country a sum not exceeding 500 pesos for a first violation and 2,500 pesos for any subsequent violation. An additional sum not exceeding 2,500 pesos shall be imposed for each month during which any such violation shall continue. Chapter is Sales Agencies and Technical Services. Title 1. Insurance Agents and Insurance Brokers. Section 299. No insurance company, doing business in the Philippines, nor any agent thereof, shall pay any commission or other compensation to any person for services in obtaining insurance, unless such person shall have first procured from the commissioner a license to act as an insurance agent of such company or as an insurance broker as hereinafter provided. No person shall act as an insurance agent or as an insurance broker in the solicitation or procurement of applications for insurance or receive, for services in obtaining insurance, any commission or other compensation from any insurance company, doing business in the Philippines, or any agent thereof, without first procuring a license to act from the commissioner, which must be renewed annually on the first day of January or within 6 months thereafter. Such license shall be issued by the commissioner only upon the written application of the person desiring it. Such application, if for a license to act as insurance agent, being approved and countersigned by the company such person desires to represent, and shall be upon a form prescribed by the commissioner, giving such information as he may require, and upon payment of the corresponding fee hereinafter prescribed. The commissioner shall satisfy himself as to competence and trustworthiness of the applicant and shall have the right to refuse to issue or renew and to suspend or revoke any such license in his discretion. No such license shall be valid after the 30th day of June of the year following its issuance unless it is renewed, as amended by Presidential Decree No. 1455. Section 300. Any person who for compensation solicits or obtains insurance on behalf of any insurance company or transmits for a person other than himself an application for a policy or contract of insurance to or from such company or offers or assumes to act in the negotiating of such insurance shall be an insurance agent within the intent of this section and shall thereby become liable to all the duties, requirements, liabilities and penalties to which an insurance agent is subject. Section 301. Any person who for any compensation, commission or other thing of value acts or aids in any manner in soliciting, negotiating or procuring the making of any insurance, contract or in placing risk or taking out insurance on behalf of an insured other than himself, shall be an insurance broker within the intent of this code and shall thereby become liable to all the duties, requirements, liabilities and penalties to which an insurance broker is subject. Section 302. Every applicant for an insurance broker's license shall file with the application and shall thereafter maintain in force, while so licensed, a bond in favor of the people of the Republic of the Philippines, executed by a company authorized to become surety upon official recognizances, stipulations, bonds and undertakings. The bond shall be in such amount as may be fixed by the commissioner, but in no case less than 100,000 pesos, and shall be conditioned upon full accounting and due payment to the person entitled thereto of funds coming into the broker's possession through insurance transactions under license. The bond shall remain in force until released by the commissioner or until cancelled by the surety, without prejudice to any liability previously incurred thereunder. The surety may cancel the bond on 30 days advance written notice to both the broker and the commissioner. Upon approval of the applicant must also file 2 errors and omissions professional liability or professional indemnity policies issued separately by 2 insurance companies authorized to do business in the Philippines, satisfactory to the Commissioner to indemnify the applicant against any claim or claims for breach of duty as insurance broker which may be made against him by reason of any negligent act, error or omission whenever or wherever committed or alleged to have been committed on the part of the applicant or any person